The February 15th, 2024 hearing for the Planning and Land Development Regulation Commission is now called to order. And if I could please have everyone silence any audible devices that you may have. And if you could join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning, everyone. I'd like to thank you for joining us this morning. And Ms. Tucker, could I please get a roll call?
Good morning, members. Member Craig?
Present.
Member Bender is absent. Member Shelley?
Here.
Member Costa?
Here.
Member Patterson is absent. Member Sixmo?
Here.
And Chair Mills.
Here. Thank you, Ms. Tucker. Ms. Craig has asked to attend the meeting today remotely, and she's up on their screen there. Good morning, Ms. Craig.
We will have to take a vote on that to allow her to participate remotely.
Pardon me?
Sorry, we'll have to take a vote on that to allow her
Yes,
to
I'm
participate.
fixing to bring that across
Sorry.
now. Okay. And so what we need to do is the board needs to vote on whether to allow this or not, and obviously any discussion on the vote.
So vote that Ms.
If she-
Craig is
if she can
allowed?
Attend remotely or not.
Okay, yeah, I'll make a motion she is allowed to,
Will that need to be a motion, Mr. Ryan?
It will, yes.
Okay.
I'll make a motion that Ms. Craig is allowed to do it remotely.
Do I hear a second?
Second.
Okay, any discussion on the motion?
Yeah, I think that when we did this during COVID, because it was COVID, it was kind of it was a pain then. I don't want to set a precedence on the board. I think that if we can't make it, we need to call in. I'd rather be late to a meeting than have to do this remotely, because we start having technological issues with it, and people that are not here present, it just becomes a thing. But I think on this one, we'll go ahead and make that exception. We're shorthanded as we are at the moment, so I think we go forward.
And
Okay.
I would just like to put in, I agree with Mr. Costa.
Okay. The other thing too is as Mr. Costa stated, we have to have 4 for a quorum, and as we only have 4 here this morning, so it kind of puts a little bit of strain on the board when we have this. I have no issue with it today because we hadn't discussed it in the past. So if all those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. Okay. We do have minutes from the January 18th, 2024 meeting. Any discussion on the minutes?
Move to approve.
Okay, I got a motion to approve the minutes from January 18th, 2024 from Ms. Shelley and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, let's get into it. If anyone would like to speak for or against any of the cases being heard today, if you would please fill out a form at the back of the room there and hand it to Ms. Tucker to my extreme left here. We will be limiting you to a 3-minute time limit. And after the comments have been heard, I will give the applicant an opportunity to address any concerns the speakers have and answer any of the questions the commissioners may have. And at this time, I'd like to turn it over to Mr. Chris Ryan for legal comments.
Yeah. Pardon me. Yes, decisions on this body on special exception cases and cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to County Council and do not constitute a final hearing. New evidence may be introduced at the County Council public hearing. Decisions on variances made by this body constitute final action subject to an appeal to County Council. What this means is that no new evidence may be presented at the time of the County Council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent, substantial evidence on the record. Competent, substantial evidence has been defined as evidence that a reasonable mind would accept to support a conclusion. Thank you.
Thank you, Mr. Ryan. And while we're on legal comments, I would like to ask the commission to disclose for the record any ex parte communications that have occurred before or during a public hearing at which a vote is to be taken on any quasi judicial matter. And I'll start with my immediate right, Ms. Shelley.
Yes, I received a text from Mr. Thomas Huger regarding item Z24004 and V-24015. I did not respond, but it was just regarding the case before us in those two items.
Okay, thank you. Mr. Costa?
No, none.
No.
And I also had a discussion with Mr. Sandy for case V24018.
Don't forget, we have one more.
Ms. Craig, yeah.
Ms. Craig.
Oh, Ms. Craig?
I have none.
Okay, thank you so much. All right. We do have an item to be, is it continued or withdrawn, Ms. Smith?
It is to be continued to April 18th. The applicant did not make due public notice.
Okay, and this is V24019.
Yes,
Okay, I'll make a motion that case V24019 be continued, to our next meeting? Which is when?
April 18th, please.
April 18th.
Okay. Do I have a second?
Second.
Okay, I got a motion from Mr. Sixman to continue V24019 to our next meeting of April the 18th, and a second from Mr. Costa. Any discussion on the motion? Okay, all those in favor signify by saying aye.
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 Motion carries unanimously. And so now we're going to be moving on to, we do not have any unfinished old business. So we'll go right into our new business. Ms. Shelley, could I get the first case read into the record, please?
Yes, sir. Case number O-24004, ordinance 2024-06, 5-lot subdivisions.
Thank you, Ms. Shelley.
Good morning, Clay Irvin, Director of Growth and Resource Management. Before you today is a proposed ordinance that came at the direction of our county council. Back in June, we were going through the adoption of some changes to our non-conforming status ordinance for property owners so that way property associated with prescriptive rights would not be penalizing them if they came for a subdivision request. And so the council was asking about how we go through our subdivision process, and they asked us to look and see what could be done to help make it easier. And let's kind of talk about why we have subdivision regulations in the first place. Subdivision regulations are actually a consumer protection ordinance. It's basically giving folks knowledge that if they are buying a piece of property that it has been reviewed by the county staff and approved by the county council to meet zoning requirements, to meet land development requirements, and that all necessary improvements for the occupation of that lot or parcel have been met. So staff goes through and utilizes that for final engineering such as water, sewer, stormwater. They also address floodplain and wetland issues. A subdivision plat requires multiple steps. It goes first through your technical review, then second through the development review committee, which is a staff-run committee that authorizes those things, and then ultimately a preliminary and final plat have to be approved by our county council. Typically, those are on the consent agenda because they are more of a technical application, and approval by the county council is required by Florida statute. So when staff looked at this, we were trying to figure out how could we best do this. So first and foremost, we have to look at a situation where there's minimal or no engineering. In other words, there's not going to be the extension of utilities, there's not going to be the pavement or creation of new roads, and that we're looking at properties that are large enough that a master stormwater permitting process is not required. So what we did is we focused primarily on the agricultural areas, and we focused on properties that already fronted on a paved public road, so that way there's no additional engineering, there's no new right-of-way. Basically, it's a very simple process of subdividing the land to ensure that it's in compliance with the zoning regulations. So if it's A2 and they come in and they can do 5-acre tracts on a paved public road, they can do so. And there will still be a technical review. because one of the critical things we want to make sure is that are there floodplain issues and are there wetland issues? So we will require that they be able to demonstrate that there's at least 10,000 square feet out of the floodplain and out of the wetlands to ensure that there is a buildable lot and that access can be obtained to that lot. What does this do? How does this help out a property owner who may have agricultural land that fronts on these types of roads? Well, first of all, it eliminates the need for a actual subdivision plat. That is a document that's prepared by a professionally licensed mapper and surveyor. It requires setting permanent reference monuments. It's a variety of different other things. So it's not just going out and doing surveying. It's actually a great deal much more work that is somewhat costly. Second of all, it will save time. As I referenced in how the process works, if this is approved at the DRC level, then there's no need to process the preliminary plat through the county council and final plat through the county council. So therefore, there's no need for that type of processing, and they can get to doing the development a little bit quicker. Then the other aspect of it, it provides for assurance that we were talking about why we have subdivision regulations in the first place. So that way, if someone comes in and is buying one of these lots, we have on record that they've gone through this review process. We can show what was submitted to us, and there's a record so that those folks who are buying these properties are assured that they have land that is buildable, that their neighbors are not going to necessarily impact them, and that the fact is that they have all the facilities that they need for their type of development. So we see this as something that can be easily implemented. We see 5 lots as a workable number. Once you start getting into larger numbers, that creates a little bit of a problem. And I want to also reference that we already have in place an unpaved road subdivision process. So that allows for up to 25 lots to be created with a single entrance and up to 50 lots with 2 access points on a paved county road or public road. And so therefore, once you start getting into those larger numbers and you want to try and create a private dirt road, unpaved road, you can do so. This is for those property owners who have something that's simple, allows them to get in and out of the process quicker, does not create any problems with our zoning regulations, and provides us with a way to be more effective in allowing folks to use their property. That is basically my presentations. If there are any questions, I'll be glad to answer them.
Thank you, Clay. Any questions for the staff? Mr. Costa.
Good morning.
Good morning, sir.
2 questions. Number 1, why the 5 lots? Why limited it to 5 only?
We were looking at what would be, once you start going over 5, are you going to be looking at the amount of impervious areas and those types of things? And would you be necessarily looking at the need to possibly go through the St. Johns River Water Management District ERP permitting process?
How does this affect, say, some of the longstanding families in the Samsula area that have large parcels that want to divide it up and give it to grandkids, kids, et cetera, et cetera? How does this play into that?
I would say that what you're seeing is between what we did back in June, which prompted this discussion, and this will make it considerably easier.
The only restriction I see here that would be a deal killer for them is the paved road, because, as you know, Samsula is all county maintained, but they are unpaved roads.
Okay.
That also affects in the area where I'm at, off of Kersey, and let's say the folks off of Ranchette as well, that there are some larger parcels still out there.
If this board feels that it's appropriate to include that paved public roads or other roads maintained by the county, or unpaved roads maintained by the county, we can include that in there.
Once a parcel gets split into these 5 individual parcels, and say those 5 parcels are still above the minimum required for the zoning, can they be resplit again down the road?
No, sir. The way it's written is it's kind of a one-time deal. Once you've done this 5-lot subdivision, any further subdivision of the land would require a formal subdivision process because.
No time limit on this? I mean, it's for as long until the ordinance changes again?
Yes, sir.
Basically? Okay. All right. I mean, if you don't think that staff would have an issue with adding, or either deleting the paved road or just adding unpaved road as well as to that criteria, I would be supportive of this.
We were being very conservative,
Okay.
and just to kind of address the two issues and why you see staff coming up with this conservative approach. First of all, let me address your second question. It is not uncommon for folks to utilize loopholes to get out of doing the actual subdivision requirements.
Sure.
So the fact is that if we allow for multiple subdivisions utilizing this provision within the same parent track, then we would ultimately be seeing folks being able to do a subdivision that had to go through a subdivision process. So that's why we're trying to say it's one time, and if you're going forward in the future, or if that's what your intent is to create more than 5 lots, let's go ahead and do it the correct way and make sure we're getting all of the issues out and identified, so we can ensure that if there is a need for roads, we can do so.
Okay.
In regards to why we were doing the paved public road, it just makes it easier from a review perspective. I do agree that, you know, when you have a county-maintained unpaved road, it will assure that we have emergency access, access for school buses, access for garbage and solid waste. We do have some concerns because there are some areas where we don't have publicly maintained roadways. Ranchette Road is a prime example. And opening up that area would create a considerable safety issue because, again, being able to get ambulances, fire trucks down there to respond to anything would be difficult at best. Second of all, long-term, even though you may have a deed restriction that acknowledges that the purchaser of the property is on a private dirt road and the county has no maintenance, I can tell you in my 8 years here, I've heard at least 3 or 4 times per year people who live on dirt roads that have that disclaimer coming in saying, y'all need to do something when they're talking to the county council. So we just want to try and minimize that frustration of property owners. One of the things that we see is that the first people who buy out there may agree with that 150%. Subsequent purchasers who may not be paying attention to the deed restrictions don't. They don't necessarily understand what's going on, and unfortunately, it gets very frustrating for them.
Yeah, and I get some of those calls as well. I live on a private maintained dirt road, and it's only 7 of us. And so when you try to get a collective of 7 to have it graded once every quarter, which is $25 a pop, guess what? Out of the 7, maybe 3 will pony up the money. The rest of them ignore you like you don't exist. But they're the first ones to complain when there's a pothole in it. So, yeah, it's a situation. We have it throughout the county.
Yes, sir.
Hunting Camp Road, for example.
Yes, sir.
Ranchette, off of Kersey. Samsula is one of the lucky ones because it is in that county-maintained umbrella. So, yeah, I think I could go with that with a county-maintained unpaved road. We can add that into the paragraph. That would be great. So,
Very good.
all right.
Any other questions for staff?
I would just say I concur with the 5 lots or less. That's a good stopping point. Beyond that, I could see where somebody would try to maybe pull something off. So 5 lots is a good stopping point.
Thank you.
Okay. The other question that brought my attention was the stormwater plan.
Yes, sir.
These lots are going to be a minimum of 2.5 acres. And if you also have a thing in here for the floodplain, wouldn't the floodplain take care of any problems with the stormwater, being that it's that size of a lot?
No, sir, and you're correct. The size of that lot, usually what will happen is, given the setbacks, location, typically you'll see it. We just want to make sure that if we're dealing with a piece of property that is in the floodplain, and because of it, they have to come in with either extensive fill for the building pad or for stem wall construction, which may cause water to be diverted elsewhere, that we do have some sort of plan that shows how they're going to be diverting. And it would be part of the building permit. It would not require a formal stormwater permit to be processed separately for the development as a whole. It would be taken on a case-by-case basis for the building permits.
Through the building permit, correct?
Yes, sir.
Not necessarily the subdivision of the lots.
No, sir.
Okay, because it reads that for the individual lot shall be included
Okay.
and will require the issuance Well, this, as a paragraph, the sentence goes on, at the issuance of any permits. But if they want to subdivide the lots, they don't have to do this stormwater plan, correct?
And if you want us to clarify that more in
I
that
would,
language,
because it's kind of vague there, because
the stormwater
it
plan
looks
will be
like if you
required.
wanted to subdivide, then you have to provide the stormwater plan.
Yes, sir.
And I know a lot of times that's addressed on the building permit side.
Yes, sir.
Okay.
We can
Um,
clarify that. If you would make that as part of the motion, we'll clarify that that's at time of building permit.
Okay. All right, let me see what other questions I had here. He addressed the paved road issue. There again, this was brought up because people wanting to leave inherited properties and split them up for inheritance purposes, which I'm really agree upon on this ordinance. I just don't, the whole intent was to make it easier. And I don't want to add things to it as, what happens when you do have a situation where you've got a driveway going to an easement? This subdivision wouldn't apply to that.
If it
On
is,
easements.
we're not trying to proliferate the amount of non-county maintained dirt road development.
Right.
Because again, that's adding more folks that may be overtaxing that particular unpaved road. Right now, we have not had a great deal of unpaved road subdivision since those regulations were put in place in 2014, 2015. But there is a minimum design standard that addresses both stormwater and carrying capacity. And it was based on American Association of State and Highway and Transportation Officials, AASHTO's minimum compaction requirements and those types of things for up to 25 homes. So that, from that perspective, staff feels comfortable that those types of roads have duration, have ability to address the safety issues, and can go forward. Anything done prior to that, we have some dirt roads out there that are quote-unquote emergency maintained by our county, where traversing can be difficult, and adding more homes out there puts the purchasing public at risk, and we're trying to minimize that.
Okay, but the whole intent of the subdivision requirements back when it was implemented was for to address smaller lots. Is that not correct? When I say smaller lots, because we had a lot of lots, that were quarter acre size, 1 acre size, but we are looking at 2.5 acres, and we are looking at a maximum of 5.
Yes, sir.
And so I think that, because I actually live on a road that is an easement, and it's not county maintained, and we do, obviously we do have to maintain our road for access for garbage trucks and ambulance service. But, and if you say that cannot be included in a deed restriction, but shouldn't a purchaser do their due diligence and realizing what their deed restrictions are?
Yes, sir. Every day we deal with folks who are doing their due diligence, and we also are dealing with a lot of folks who don't do their due diligence, unfortunately. And in this particular situation, if the Planning and Land Development Regulation Commission feels that if there's an established easement for ingress egress, and you feel that's appropriate for this type of 5-lot subdivision, please make it part of your motion. Again, staff was being very conservative. And I gotta point out that we did have, and some of y'all, I think Mr. Sixma was here, and I know you were here, sir, when we were, did away with a lot of our exemptions in 2008. We did have, at certain points, 4-lot, 2.5 acre subdivisions that we have a considerable number of them. They're called exempt subdivisions, and are out there where there was not roads required, where it was a situation where the public could just come, subdivide their land in 2.5 acres if it met the subdivision, and go forward. And these are some of the areas that some are doing very well, some are not. And so we were trying to see what issues we were having with those previously approved exempt subdivisions, so that way we would not repeat the reasons why we got rid of them in 2008. And one of the primary things pertains to access. The big difference then is that there wasn't necessarily a ingress egress easement, with a road section that met a minimum requirement. If you want to put that in as part of your motion, we can make that a part of this pending ordinance and report that to the council and see where they go with it.
Okay.
Mr. Chair, if I can just add something back about adding in multiple lots on a private easement. The county doesn't control those easements. We don't know what the negotiation was. The easement could actually have in it a restriction no more than 3 dwelling units off of this easement. So we do not legally control the access. And, one of the concerns that, I'm thinking is if the county allows for the subdivision in violation of the easement, that's basically leading down a road of litigation where, the county would just kind of say, hey, you're on your own. Too bad you bought a piece of property that you can't do anything with. So that's kind of my concern with applying it to non-county maintained private roadways is we don't know what the restrictions and the negotiations came into when that private easement was created. There could be restrictions. It could be burdening the other easement holders who take access off of it. They may have a private cause of action against the person who is subdividing.
But that would be in the deed, would it not be, if there was restrictions of that nature?
Who knows? 'Cause
Well, I
it's-
mean,
it's a
if someone gives an easement, normally it's exclusive or non-exclusive. And so therefore, I would think that if it's had those restrictions to it, that would be, in the deed itself.
Hi, this is,
litigation on easements and the extent
And
of
the pe-
them is
That's my
I don't
connect-
want to say it's uncommon, but I have seen a few where the easement is unclear as to the extent and nature and the number of units, that can take access off of the easement. And that's something that the county does not take into account when we approve a subdivision. We don't go into the details of the easement.
I can offer a solution if you feel, if the Planning and Land Development Regulation Commission feels that this needs to be included, that it would be allowed, that it would only be allowed if the person seeking the subdivision was able to provide proof that the subdivision would have rights to utilize that private easement for ingress egress,
Yeah.
and that there are no restrictions that would limit the number of units. So that would be a burden put on the applicant to come in and provide sufficient evidence that use of that private ingress egress easement would be allowed.
Okay. Okay, Ms. Craig, did you have a question or a comment?
no, I'm sorry, I lost my connection for a minute, but it came back on.
Okay.
My apologies.
Okay. All right, if there's any more questions?
Do we need to, have this come back, or should we just make the adjustments here?
That's your call. If you feel that making as part of your motion the 2 items that you've brought up in regards to allowing for access onto and I would say that it needs to be called out. If you feel confident, we can take forward with that, given the motion, we can take it forward. If you feel that you would like to see the actual language, come back to you and go through it in greater detail later on, it's your call.
We can discuss that during the
Yeah,
motion.
we'll discuss that after the thing.
Okay.
Okay. Do we have any public comments for this? Okay. Is anyone like to speak to this case? Yes, ma'am.
I have a public question.
Okay, you can come forward and state your name and address, and after that, you can fill out a form and give it to Ms. Tucker to my immediate left. No, just go ahead now and then give it to her.
My name is Cynthia Blumquist. I live on Arredondo Grant Road in DeLeon Springs. I just am a little confused. I'm not aware of this ordinance and its detail, but I heard Mr. Costa say that the intent was to allow familial gifting of plots to families, and that was why this whole issue has come before the county, am I correct? That was the intent?
Part of the issue, that was the intent, is to make it to where if a property owner had a large parcel and to do any kind of gifting or inheritance to their family members. But this does not necessarily be strict to them. This can be to anyone.
That was my question.
Yes, it can
Okay.
be to anyone.
So it's really opening
But
up the
that was
door
the
for
reason, that
anyone
was
to
the
subdivide.
whole purpose behind it, was this is the reason the discussion was ever brought up.
I see. So that is the reason it was brought up,
Mm-hmm.
but that's not going to be any requirement that
That
there
it be a
be a
family member?
familial connection.
Not the way this
In other
ordinance
words,
is
it can
written.
just be sold and developed.
Well, there again, depending upon the size of the parcel, what the zoning is, the minimum size would be 2.5 acres.
I just needed that clarification.
And it has to be one of the zoning classifications of A1, A2, A4, forestry resource or resource corridor zoning.
And
classification.
A3 is not included in that.
Which one?
A3?
A3, no, because A3 is a 1 acre,
Okay, thank
so
you.
that way it'd be too small.
All right, I appreciate
Okay.
it.
Mr.
Just to clarify about the family situation, subdivision of land is like death. You either are or you're not. And so once it's subdivided, it can be sold.
Yeah.
So the fact is that we have no way of basically what would be called a clawback. So if I wanted to deed it over to my two daughters and then I pass away and they turn around and sell it, there's no way for me to make them whole again. So it's again a enforcement situation that we can't just make it tied to family transactions. Okay.
Okay, thank you. Any other questions? Any other folks? All right, we're going to close the floor for public participation, open up for commission discussion. I'd like to bring up the point of what we talked about of the clarification on the stormwater. We do have a floodplain clause in here, so the stormwater could be brought about at the time of permitting for any development rather than at the subdivision. And then, of course, the easements, if you would like to include that, or if you want to keep it.
I'd like to see, I mean, as you were talking, I'm thinking back in my particular case, yes, my road is also, even though it's a private road, it is actually an easement granted through that particular larger parcel when it was subdivided. So I think I personally would like to see how this language looks on paper before we pass this and move it up, kick it upstairs. Because I really do think that easement, whether it's a publicly maintained non-paved road or a privately maintained non-paved road, it shouldn't be of any consequence. I think that goes back to the landowners themselves, and I think that how it's structured and written. I'm not an attorney, but I definitely would like to see it in writing.
I totally agree. If this was going forward, if a motion, my vote would have been no. I really would like to see it fleshed out and read through it.
Okay. I'm going to ask Mr. Irvin to come back. And Mr. Sawyer, would this go as a continuance, or would it go?
I would recommend that you continue it to a date certain, so we don't have to re-advertise it.
Okay.
Okay.
We can bring it back next month.
Yeah.
Next month's really busy.
You have a 2-hour workshop and 14 items to review next month.
A what?
Yeah.
Okay, we can do it in
Talk
May.
about that later.
I don't know. Why not make it a longer?
Yeah.
We're already
But
here.
Mr. Irvin, hopefully we've given you some idea of what we're looking at.
Yes, sir. We can make the corrections that y'all have asked for, and we can bring it back, whatever is most convenient. As I said, we can have it ready for April, especially if it's continued, because then we don't have to worry about advertisement and those types of things
Yeah.
and posting. But it'll be simply your call if you want to tack on to a long meeting or if you want us to bring it back in May.
All right, sir. Thank you very much.
April 18th is,
We're looking at April? April.
April 18th is the
18th.
next, is the,
Chairman,
meeting in April.
I'll make a motion then that we continue.
before we go, could I ask a
Yeah, Ms.
question?
Gregg?
The issue of the clawback that Mr. Urban mentioned, is there a way of attaching it? Sorry?
The way what?
Is there a way for a deed restriction to be attached to any of the subdivided lots so that it could be held in the family?
That's a question for Mr. Soria.
So Florida does not like restraints on alienation. We do not like, to restrain people from buying and selling a whole piece of property, and putting in more restrictions on who can own it. You're going to have to get into that thorny issue of who is the relative, how far along down the bloodline. Like this is all like
It'd
property,
be
nightmares of property law 101 is the
It'd be a regulation
consanguinity.
holding you hostage too.
Yeah. It's been a while since I remember what the rule against perpetuities was, but it's one of those like law school nightmare
Yeah.
issues.
Okay. Does that answer your question, Ms. Gray?
Thank you, it does.
Okay.
Let's avoid the nightmare.
So regarding the continuance, why, are we skipping March because that's when we're loaded up?
I thought we said April.
April 18th is, if that's the motion, you can go do it.
Well, that's
on
my
an
question,
April
though. Are we skipping March's meeting with this because we're overloaded on March? Is that the case?
18th. I believe so. We just kind of
Okay, all right. I just was wondering why all of a sudden we went to April. So that's all right. I wasn't listening. So that being the case, let me make a motion that we can continue case O-24-004 to the April 18 PLDRC meeting.
Second.
Okay, I've got a motion on the floor to continue O-24-004 to our April 18th meeting from Mr. Costa and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously. Let it note that Mr. Patterson has joined us. Okay. I'm just letting you know. We have to put it in the record. All right.
Chair, before I leave out, first of all, thank you all very much for the guidance, and we'll follow through. We're running a little behind over in our land development section right now because we have some staff out, and so I would like to kind of jump forward with one staff comment, and that's welcoming Amy Michaels. She is our new land development manager. She's replacing Samantha West, who has taken on a new position in environmental management. And Amy comes to us from Orange County, and prior to that, she was working out in the Vegas area. So she's bringing a great deal of knowledge, a great deal of experience, and we're very happy that she's part of our team. And just wanted to make sure y'all could put a face with a name, and we're looking forward to having her take over and give us some new insights and helping us up with our land development aspects.
Okay. Thank you, Amy. Thank you, Mr. Urban. Okay. Next case, please.
Case number V24-011, variances to the minimum yard requirements on urban single-family residential R9 zoned property.
Okay. Get my cheat sheet on that. Okay, Mr. Hanson, this one is yours.
Good morning, Michael Hanson, Planning Development Services. This particular variance application has 4 variance requests. It's for a non-conforming lot that is zoned R9, and it's resultant due to structural fire on the property back in 2022. So due to our non-conforming ordinance, we have a requirement that in the cases where there's damage exceeding 75% of the property, reconstruction has to meet our applicable zoning ordinance. So the 4 variance requests that you see on the variance site plan there are to enable the reconstruction of the property in essentially the similar footprint of the previous home that had been constructed back in 1987, that had received a variance back in 1987 to allow its construction. Staff evaluated the request and has a recommendation for approval on all 4 variance items. I'm available for any questions the PLDRC may have.
Thank you, Mr. Hanson. Any questions for staff? Hearing none, is the applicant present? Good morning.
Good
Name and
morning,
address for the
everyone.
record, please.
Jessica Gallo, Cobb Law Firm, 149 South Ridgewood Avenue in Daytona Beach, Florida. Want to thank staff for this recommendation. I don't know that I've ever had a 5 out of 5 recommendation before you guys. So I think that this case obviously started with the tragedy with the house fire. And it really illustrates, I think, the reason we have variances, the reason why we can come forward and say, in this circumstance, having a non-conforming use is not injurious to the surrounding area. It's not something that needs to be phased out. We're just asking for this home to be rebuilt. We actually came in with just one variance, which was the waterfront setback, because it's measured by the coquina revetment, which you can see is kind of in the middle of the property here. Same with all the properties kind of along the strip. And we actually have a deck that survived the fire. I think you've got a picture in your staff report that goes over that revetment. And so they're already beyond the coquina revetment in terms of other improvements to the property, just like all the other properties down this road, and we're building landward of that. And so we came in for the setback for that. And then once we start looking at detailed setbacks and things with the planning department, we found out, there are a couple other little pinch points. The coquina revetment is actually a little crooked, so it's 7.5 on one side and 6.6 on the other. And so we're really just trying to rebuild this home exactly as it was. And if you have any questions, happy to answer them.
Any questions for the applicant? Okay. This waterfront setback, that's to the ocean side, is that correct?
Correct.
Yeah. Is the setback for the coquina rock, or is it for the deck itself?
No, we measure the setback from the coquina revetment. And so from the water line to the
Yes.
coquina is about 25 feet. And then you measure the 25 feet actually from the coquina revetment landward. And so that's where we have, like 6.5 feet from the coquina to the start of the deck. But the lower deck that exists extends beyond the coquina revetment, and that's existing.
Okay. All right. I hate to keep on asking, but the lower deck,
Mhm.
does it go past the coquina rock
Yes,
into the,
existing.
towards the water side?
Correct.
Okay. All right.
Thank you.
Okay. Any other questions for the applicant? Do we have any public participation forms? Okay. All right.
I'll be glad to make a
All right,
motion.
we'll close the floor for public participation and open up for commission discussion or a motion.
I'll be glad to move. I move that variances 1 through 4, case number, V2411, as the variances meet 5 of the 5 criteria for granting and said variances. Move to approve.
Who seconded it? Mr. Feddersen? Okay, I got a motion to approve variances 1 through 4 from Ms. Shelley and a second from Mr. Patterson. Any discussion on the motion? The only thing I'm concerned about is that setback to the ocean front with 6.5 feet. The deck going past the coquina rock. But I guess you have to get over it, don't you?
Sir, if I could clarify your question, as Ms. Gao said, there's an existing deck that
Yeah.
expands past the coquina that provides beach access. The variances that, for that first one that reduces it down from the waterfront down to 6.5 is for the reconstruction for what's already there. So that waterfront setback's 25 feet. And based on our code, we measure from the interior side of the revetment, as Ms. Gao said. So that variance request is just for the new. The existing is already in its current condition and was permitted.
And it's specific to the deck, correct?
The deck in the house, yes, sir.
Well, wait a minute. The deck in the house, you can't put the house 6.5 feet from the water's edge. And
No, the deck is what goes to 6.5 feet. So, but as you can see on the variance site plan, that the house comes back from the waterfront setback. So, and the deck is attached. So, but the house is at 25 feet, but the deck is what goes to the 6.5.
So my question is, the variance is specific to the deck that is there now for the reconstruction. You can't put anything else over there other than the deck, because normally the variance goes with the property. Mr. Paulo.
I'm trying to look at, so the variance number 3, right? That's what we're discussing? That's, I guess,
Variance one.
well, in regards to the house, like, is there any portion of the house that requires the relief from the waterfront setbacks?
The portion that requires relief from waterfront setbacks is covered under variance 2, which reduces that 25 down to 17.5.
Yeah, that's for the residents.
Yep, that's for the house, and then the other part that is for the deck that you're talking about is variance 1, and that's just for the reconstruction of the new deck. So
So specific to the deck, correct?
that's correct.
Okay, that's my question. Okay. All right.
We got a motion in a
Yeah,
second?
there is a motion and a second. All those in favor signify by saying aye.
Aye.
Any-
Aye.
Any opposed? Motion carries unanimously.
Thank you.
Okay. All right, Ms. Shelley, could I get the next case, please?
Yes, sir. Variance V-24-013, variance to the minimum yard requirements on rural residential RR zoned property.
Mr. Hanson, this one's yours also.
Good morning, once again, Michael Hanson, Planning Development Services. This particular variance request is for a rural residential zone property that typically requires a 1 acre minimum size. The property is non-conforming to the minimum size and with requirements. However, due to our non-conforming ordinance, separation is not required. When evaluating the request in order to site the proposed house on the property, we're looking at a variance reduction from 40 to 34 feet, and staff made the recommendation that it failed to meet 2 of the 5 criteria for granting the variance and has an overall recommendation denial. If you look at the site plan, part of the uniqueness of the property is because of the way it's configured off of Carr Street. It sits at a 110-degree angle, which if it was perpendicular to Carr Street, the applicant could actually construct the proposed residence on the property without variance. However, the portions of the criteria that fell due to the proposed size of the residence, that puts it at approximately 1,800 square feet, where the rural residential zoning classification only requires a minimum floor area of 1,000 square feet. So potentially they could, construct a smaller home on the lot. I'm available for any questions the board may have.
Thank you, Mr. Hanson. Any question for staff? Hearing none. Is the applicant present? Good morning.
Good morning. For the record, Nika Hosseini with the law firm of Cobb Cole, 231 North Woodland Boulevard in DeLand. It's a hard act to follow when Jessica gets up here first. But I will say, want to give thanks to staff for working through this. This is a really interesting one. So a little bit of history on this. In 1955, there was a 9-lot subdivision that was created that had each of the lots at 10,500 square feet, so way below the minimum acre. That was permitted, it was approved through the county, and over time, then you had a zoning ordinance that put rural residential, which requires 1 acre. All of those 9 lots, which I think you can, if it was zoomed out, you can see they're all, on that same, perfect, thank you. All those 9 lots were slowly after it became residential, they became non-conforming automatically by the zoning code. And a couple of the lots, they were able to combine and create a bigger lot and move forward and not have to, come in for any variances. A couple of the other ones had the same, are still configured around 10,000 square feet, and they have houses on them. This is the only lot, part of that 9-lot subdivision, that does not have a house. And like Michael said, and he pointed this out to me as well, is part of their non-conforming lot ordinance is If the lots next to you have houses on them already, you can't combine them with a vacant lot. And so we couldn't go and try to purchase, an already built house. If there was 2 vacant parcels, then we can combine them and it would make sense, and we would move forward that way. But this is the only lot that does not have a house built on it. Another interesting point about these 9 lots is that 3 of them currently do not meet the rear setback. So if there's a structural fire like that happened, with in Jessica's case, you're going to have multiple homeowners coming here for variances, the same exact variance you're looking for. Another point is that each of these homes are well over 1,000 square feet. So if you look at your requirements regarding what needs to be met, you can see that it states that the variance granted is the minimum variance that will make possible the reasonable use of the land. Now, minimum does not mean reasonable. So you can have a minimum requirement, but is that what is reasonable for the land we are looking at? And clearly, all 8 of those properties, excluding ours, has well over 1,000 square feet of under house, under roof. And that's all we're asking for here, is the same thing that all those 8 others have. So I understand the perspective of the county, but again, reasonable use, in my opinion, looking at that, where you have a septic tank, a drain field, so we had to push the house back, the angle of the house that is currently there, all of those clearly illustrate that we do in fact meet the requirements of the variance. And as a result of that, we do respectfully request approval, and I'm happy to answer any questions or get back up here if anyone needs me.
Thank you, Ms. Husseini. Any questions for the applicant? All right, we do have some public participation forms, and I'll allow you for rebuttal. Okay. Let's see here. Mr. Wilson.
Well, Attorney Curtis Wilson with McCalla Raymer here for the neighbors, both at 1820 and 1815 on either side.
I need your address, sir.
Yes, it's 389 Sprucewood Court, Lake Mary, Florida, 32746.
Okay.
And I represent, I was brought in by Mr. Egner, who is the homeowner at 1820, which is directly on the lot left of the property. And I also have since been asked to assist the Keaches, who are at 1815, which is the right side lot. The history, as she said, on this one is very unique in that they created these lots already small and at a weird angle. What people don't seem to realize is that at some point due to a divorce, this lot was actually subdivided already into even smaller, very, very difficult to use lots. And it's been sitting like that for a long time. In fact, Mr. Keach and Mr. Egner have been mowing that land, keeping that land up because it's a small strip of land separating their properties. In fact, it's the only land that Mr. Egner can get to the back of his property where his garage is. If this was to have a house built there to the specifications they're asking for, going into why the variance was already why the denial was already being considered, we would not be able to access our backyard at all. His garage is back there, his shop is back there, everything's back there. I have pictures of the lot lines, if you'd like to see, where it shows that his driveway would be cut in half. Now, if you look at the neighborhood, this does not conform to the neighborhood at all. Each of the lots is about double the size, if not triple the size, of this piece of land. That's because this land was already a small lot in the neighborhood. If you look at it, it's smaller than any of its neighboring lots. And then it was subdivided in half with Mr. Egner's property on the left side and a small strip, I'm talking 80 feet is all this thing is frontage, at an angle. I don't see any way that you're going to be able to fit a septic tank and put in a land there and a big house, an 100 square foot house, without both affecting the Keach's land and Mr. Egner's ease of access. And the real problem is, of course, to the angle of this thing. It is at a strange angle where the driveway literally would be stripped in half for Mr. Egner at 1815. We have for the board pictures of how the land would cut across this property, as well as the
Yeah, you can submit that to Ms. Tucker. Now, that will become part of the record.
I have Ms. Keach here as well. Both parties, the Mr. Egner and Ms. Keach and Mr. Keach, have offered to buy that land because it was part of Mr. Doug Egner's land in the beginning. That's been refused. All they want is to keep the lot lines the same they were when this was subdivided originally, which is keep that land bare because it meets with what every other property size is in that neighborhood. Okay. I'm sure that's a timer for me.
All right, thank you. Any questions for the speaker? Mr. Costa?
So, just to clarify, so the house to the left of this lot, looking at the pictures on the aerial, is there an easement between those two properties that he's using to access his barns on the backside?
There is no, I don't believe there is a written easement. Again, this was one piece of property. It was subdivided before either of these parties bought
Okay,
this property.
So he's basically to gain access to his outbuildings, he is going over someone else's property.
Yes, by technicality, yes.
Thank you.
Any other questions for the speaker? All right, sir, thank you. Ms. Keach? Good morning. Could I get your name and address for the record?
Good morning. I'm Beverly Keach. I live at 1815 Carr Street. All right. In 2013, Paul Aguero wrote me a letter and asked me to buy the property because she had acquired it in a divorce. And she was being wined and dined by the man that owned the duplex, and she was fed up. So she wrote this letter to me and my husband asking us to buy it. At the time, I was also going through some emotional things. So you got one emotional woman, and let me show you what we did. I have her original, and I'm shaken because that woman is in heaven. She took her life over this. She gave me this, and we did everything on a piece of paper.
Ma'am, if those are original documents,
This is what she
please
gave
don't
me.
submit that to us because we have to keep those.
I will give them to you, but I
Okay.
want copies. I want my copies back.
Oh,
I don't mind. But what I am saying is, she told me in 2013 this property was worthless. We were going to buy it just so we didn't have a neighbor. Where is the well going to go? Where is the septic going to go? Our well is up there at the top where you're talking about putting this house. We were told by James Evan Drilling that eventually we're going to need a new well. We live in Glenwood, a bird sanctuary. If I wanted to live neighbor to neighbor, I'd live downtown DeLand. I live in Glenwood. I enjoy the birds, the bears, the raccoons, and the possums. You keep bidding buildings in Glenwood, where are these animals going to go?
Okay, anything you submit, you will not.
So
it
I am
becomes part of the
against
record.
it. If you put anything, there's going to be cars there, there's going to be houses, then everybody's going to have tiny houses everywhere. And Glenwood will not be the beautiful community that it is.
Thank you. Okay. Ms. Matson? Ma'am, if you will not get them back if you submit them for the record.
I'm not submitting it because this is in honor of Paul Aguero.
Okay. Now, you can more than welcome to make copies and give it to them if you'd like. Okay, Ms.
I'd just like to
Matson.
clarify that because she has not submitted those, you don't consider those as part of the record. I'm not sure what you would consider. You consider her verbal statements, but I didn't get a good look at the documents. I don't think you did either.
No.
For all intents and purposes, we don't know what was said in those.
Okay. All right. Ms. Matson? Can I
Yes,
get your
my
name and
name
address
is-
for the record?
My name is Gail Matson. I live at 1619 Carr Street.
Okay.
I have lived there since, for the past 25 years. We built our house on 3 acres, which was required to have 2.5 acres to build the house there. There's no way to see what Carr Street looks like, but this particular duplex that's next door, and then this property is the smallest property on the street. Most property owners own an acre, acre and a half, 3 acres. I actually have 8 acres. We are an area of large homes. We have a lot of money into our homes. My house is a 4,000 square foot house. There are other homes that are equally large. This variance that they want to do to put up a 1,000 square foot home, which is the minimum, would not work for our area. If you allow this to happen, then other people will speculate and buy homes, which this is a speculative lot that was purchased. It's not a person who wants to live there. These lots are all, if you will look at the area, they are plotted on an angle. Everyone's home is on this particular angle that you said is a variation of what is done. Those homes are all angled. So, you know, this is a rural residential. It's supposed to be a 1 acre as a minimum. So we pay property taxes. Everyone on that street is paying a lot of property taxes, and we expect to have our property, to have our investment protected with what we have expected to be there. I have spoken with several of the other neighbors who are unable to be here today. The Reeses, the Wrights, there are some other neighbors who would like to speak. But this was, the staff recommendation was to deny the variance, and that is exactly what we expect to happen. There are homes on either side that, if they were given the opportunity, would probably buy that property, which I understand was sold for $17,000, which you cannot touch a piece of property in Glenwood for $17,000. So to allow it to be bought for that, and to have a variance for a home that would be a small home, would be the only thing that would fit there, and it would not fit in our area.
Thank you, ma'am. Any questions for the speaker? Thank you.
Thank you.
Teresa, and I hope I don't mess this up, Goosey? Could I get your name and address for the record, ma'am?
Teresa Goosey, 1740 Carr Street.
Okay, and you had some comment you would like to add to this?
I don't think that lot is big enough for a house. We are, like Gail said, 1 acre or more, and I don't think it should be built. And I deny that variance.
Okay. Any questions for the speaker? Okay, thank you, ma'am. Okay, that does it for the public participation. Is there anyone else that'd like to speak to this case? Okay, hearing none. Ms. Husseini?
Good morning. So a couple of notes. I think there's some confusion about what this variance is. There is a right for it to have a house built on it. We are not here for the size. We're not here for the side yards. We meet the side yard requirements. So those two neighbors, there are no variance here to infringe on those side yard requirements. We meet the front yard. The only thing we don't meet is the rear yard. No matter what happens, a house can be built on this property today. So with respect to size or not being able to reach a backyard because you need to trespass on other property, frankly, that's not what variances are for. Frankly, you don't have the right to go onto somebody else's property without an easement. And so all we are asking for is the rear yard, which interestingly enough, the individual on the left is also a non-conforming house that is very similar in size to ours, and the individual on the right does not meet the rear setback either. And so again, this is very consistent with the neighborhood. It's if you look at those 9 lots, they were 10,500 square feet when they were originally platted, and they've changed over time. And if you look at any other urban zoning, like R4, for example, which is similar to kind of what the original configuration was based off of, the front setback and the rear setback are half of what rural residential is. So you're constricting this property by squeezing it in. So again, I can understand that, individuals might not want to have a house built, but that is not what we're here for. The variance requirements, based on my review of them and our discussion, have clearly been met. A house will be built here no matter kind of what occurs. Our goal is to provide something that's reasonable, that does bring up property values in the area versus a very small house that would not help and not make reasonable use of the land. So I can appreciate their comments, but looking at the criteria and looking at this lot in particular, it's clear we meet those criteria, and we respectfully request approval. Thank you.
Thank you, Ms. Husseini. Mr. Costa?
Yep. A couple of questions. So, can you put that picture back up, please? Any chance we can't zoom into that, can you? I'm looking at the dotted lines on that particular exhibit up there. And obviously, it would be an odd-shaped house, but you could technically build out to those dotted lines inside
Correct.
that property,
Correct.
which would give you not only 1,800 square feet, but probably close to 2,100 square foot if you wanted to, without any variances required.
Correct.
So we're not talking about whether or not this lot can be built on or not.
No.
We're talking about a 6-foot setback because of the angle of the property, period.
Correct.
Secondly, have you submitted for a building permit yet? Has this been?
We did, and they came back saying you must go receive a variance first. before
Variance
you
first.
proceed.
So in other words, going back to some of the other questions that or objections that came up, the location of the well, the location of the drain field, the location of the septic, none of that has been in stone yet. So you don't even know that it can go as is currently
Correct.
shown on this preliminary site plan.
Correct. We are not allowed to move forward until we get this variance.
Until you get the variance. And then staff will determine which, where, when, and how. And that may actually limit the overall size of the
Correct.
the finished buildable size of the house.
Correct.
Okay. I just wanted to get that out in the open then. Thank you.
Thank you.
Any other question?
Yeah, I would like to actually hear your side since you're the septic. You got any thoughts on this?
Well,
You're the septic expert.
Well, you only have to have 5 foot off the property line, first of all. And the unobstructed area is not a problem, even with that size of a house on that lot. It is an RR zoning, so obviously the setbacks are greater than regular residential. And you can put a septic on a 1/4 acre of residential, so yeah, they can meet that requirement. And as long as that well is 75 feet from any wells, they can meet that requirement. So yeah, it's a buildable lot. The question is, as Ms. Husseini said, is not the fact of whether it's buildable, it's whether we're gonna allow the 34-foot setback from the rear property line. And even if we were to deny it, they can still build. And it's still a buildable lot.
But that would, if we did give them a variance, it would allow for at least a larger house, correct?
I don't know about that, because I
They
don't
would
know
have
what
to
can be-
reconfigure the house.
Configure,
yeah.
all right.
Yeah. Okay. All right, we're going to close the floor for public participation and open up for commission discussion. Ma'am, I've closed the floor, and you've had the 3 minutes. Okay, I apologize for that.
Well, let me make a motion so we can go to start with the discussion then.
Okay,
You ready?
yes.
All right, so I make a motion on case V-24-013 that we approve the variance number 1 with the 1 staff recommended condition.
Second.
Okay, I got a motion on the floor to approve variance V-24-013 with the staff recommended condition from Mr. Costa, and a second from Ms. Shelley. Any discussion on the motion?
So, yeah, let's discuss this a little bit, because I know that we've got some folks here that are a little
Yeah.
heated about this, and I understand their position, but I also understand the position, we're talking about property rights here. And this is not an issue of can you or can you not build on this lot. This is only an issue of can we put that back up on there, on the screen? Whether or not that one corner of the house is able to slide over 6 foot, and that's the variance that we're giving them, is just for that one corner. So technically, if they lop that corner off of the house, this variance wouldn't even be required. Because you more than meet the setbacks on every other side, all other 3 sides of the house. And that's why I am in favor of this particular variance here. I don't see any harm in any foul on this one.
And I'll ask Mr. Hanson, that RR zoning there is more restrictive than regular residential, correct? It'd only be 25 feet on a residential, correct?
Well, there's a number of different residential zoning classifications, and depending on which urban single-family residential zoning classification, rear yard setbacks get significantly smaller, around 20 feet. However, you're right, with the RR, rural residential zoning classification, it has a 40-foot rear yard setback because
Yep.
it's typically an acre size.
Okay. So, I mean, we can't stop them from building. I mean, that's not gonna happen, as you stated, the personal property rights. I do sympathize with them. I understand what they're saying, but unfortunately, the actual stopping them from building is not in our hands. We're just looking at the variance on the setback to the rear yard. Okay, any more discussion? That's correct. Okay, we do have a motion on the floor, so all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Did we get,
That's an aye.
there you go.
Okay. Next case, please.
Just for the record, that is 5-1
Oh.
to approve with Ms. Craig denying.
Oh, she denied it?
I thought she said.
No,
She said aye.
I said
In
aye.
favor.
She was
Oh,
in favor.
okay.
She said aye.
And
Okay,
I
she
do
said
have
aye. Okay.
Yeah.
Okay.
There was one staff recommended condition.
Yes, I
Yeah,
added
we
that.
Did you
added
add that?
Yeah.
Yep, I did.
Okay.
Okay.
And as a point, just a point of order, did we add that to the first item, the staff recommended condition in our motion, in my motion?
I don't think so, because
I
staff.
don't think we did.
Well, staff recommended approval, so I
Yes,
don't
but
think
they
there
had
was,
two conditions
I don't know, we can go
on page
backwards.
5, so, because I didn't think they did originally, and then when I looked, I was like, wait, they're limiting it to certain
We don't want to
places.
address that at the end?
At
towards-
the end,
yeah.
yes. Just wanted to bring that
You
up
want
as
to
a
just
point of
pull
order.
that out, so we'll look at that at the end?
Absolutely.
Okay. Okay, just pull it out, we'll address that at the end, just
Perfect.
don't forget to bring it. Okay.
All
right, our
I'd
next
just like,
case, please.
would like to notify the people in the back of the room, if you are going to have conversation, please step outside the chambers as we still are in session. Thank you.
Okay. All right. Ms. Shelley, can I get the next case, please?
Yes, sir. Case number V 2414, variance to the minimum yard requirements on transitional agriculture A3 zoned property.
Okay. Mr. Hanson, this one is yours also.
Good morning once again, Michael Hanson, Planning Development Services. This particular variance is for property off of Arundel Grant Road that is zoned A3. It was part of an antiquated plat from 1925 that comprises 3 lots of that plat and does have a subdivision exemption that was approved previously. The property, as configured, sits on a county-maintained public road, and because is exempt from the subdivision regulations, it technically has vested rights, so the lot in question is buildable. So as I go forward with the staff report, the variance requests are limited to just the dimensional setbacks that you see. In order to site the proposed house, which is 2,379 square feet, the applicant has requested the 4 variances that you see forth on the site plan. The house is similar in size to the surrounding developmental pattern of the area. The one thing to take in consideration as well with the uniqueness of the property is it is a corner lot. And the size of the property is 9,147 square feet, but that west property line also fronts on an unopened county or unopened right-of-way, presenting a front yard. So that's why it has that extra front yard variance for the A3. Based on the angle of Arundel Grant Road, it kind of curves northward, and that's why variance 4 is requested at 25 feet based on the configuration of the property. And overall, for the recommendation of this particular, all 4 variance requests, it failed to meet 2 of the 5 criteria for granting said variance. Otherwise, I do have 1 staff condition on the report, should the PLDRC choose to approve the variance. I'm available for any questions you may have.
Okay, any questions for staff? Hearing none, is the applicant present?
Good morning. For the record, Michael Woods with Cobb Cole, 231 North Woodland Boulevard here in Deland, on behalf of the property owner Robert Wilkins. I'm the old gray mare of the Cobb Cole trio today. It's a pleasure to be in front of you guys all today. If you could pull up page 11 on staff report, and then we'll pull up my presentation as well. What we're here to do, kind of similar to some of the conversation from the previous applications, is we do have a legal lot of record that is buildable, and trying to comply and make it work with a zoning category that clearly did not contemplate a lot of this size. The history of the lot, and Mr. Hanson touched on it briefly, it is a vested lot because the front portion of the property ran along Arredondo Grant Road. It was a paved, improved, accepted right-of-way by the county, which made that portion of the lot legal. And technically speaking, before 2004, that legal part of building was just, if you look on your page 11 there, just that block 1, lot 44, that frontage. In 2004, that exempt subdivision that gets referenced is when they added on the additional 2 parcels, right? So basically you can take a non-conforming lot, and if you add more property, you can continue to maintain that non-conforming lot, and you're trying to address the overall problem. So since 2004, that's been the configuration. Legal, we can build, but we're still dealing with how do you build on a 9,100 square foot lot, give or take, while applying A3 zoning classifications? And the reality is you can't. You got to come up with another standard that kind of applies for it. So if you could pull up my slide presentation, please. Okay, if you can go to the next page. Or do I have access to it? Thank you. So mainly what your application provides for, because of the size of the lot, and I've tried to give a comparison here, is a minimum lot size and dimensions utilizing the R4 zoning. Because it's basically a single family lot that we're trying to work with here. Just to give you kind of the frame and comparison of what we're asking versus what would otherwise be required for the A3, 1 acre, 7,500 square feet, we're at 9,100 square feet, so well in excess of that. Minimum lot width, we're at about 100 feet width frontage. Really our big challenge is coming from that Arredondo Grant angle. That causes some problems for our septic and for our rear lot setback. From our minimum fronts and for our sides, Mr. Hanson referenced that 25-foot corner, and he's the one that kind of caught that because of the angle on Arredondo Grant, but otherwise we're 30 feet from the garage front. And that lot is kind of configured in that way because of our septic field where that is located, and that's due to the expected location of the well on the northwest corner. Our minimum rear is really the only place where we further encroach, even if we are coming in with R4 zoning, and we can talk about that as well. And then from the minimum side, keeping in mind that that western side is technically a front yard because of that platted roadway. We come in, if you compare it to an R4 zoning, it's usually 20 feet combined, 8 on either side. We have 30 feet on our west, 16 on our east. And then the minimum floor area is the question that we kind of get tripped up on with the staff review on the criteria, right? It's 1,000 square feet in A3, 850 in R4. We're coming in at 2,300. You're about 1,620 of livable space without the garage, without the porch. But that minimum criteria is really that. It's to ensure that you don't have a tiny home out in the middle of your acreage in your woods, but it's not really designed to set as a maximum for the floor print when you're coming in for a variance. To that end, I want to kind of be able to show to you the consequence of taking an application like that and assuming that if you need a variance in this A3, that you would be somehow confined to only 1,000 square feet of a footprint. So this is our neighborhood here. Okay, there we go. Just to kind of give you the lots along the south, running from west to east, 1 through 6, and then 7 and 8 across the way. I'll show you, we're at the top right of this page, a little bit up, but I just wanted to kind of show you what we're dealing with our neighborhood. These are the parcel numbers, these are the parcel areas. Again, all same zoning category, all supposed to be at least an acre. All sub 1 acre lots for these. And you can see the building sizes here varying from 1,355 feet all the way up to 2,600 square feet. Further on, going on with the rest of the neighborhood, this is going a little bit farther to the east, and I had a star, but if you, I hope you guys can understand, if you look at the lot number 13 and go 2 lots to the left, that's where we are. Again, showing these, and some of these are a little bit larger lots. You know, we do have a few that go to 1.26 and 1.23 acres, but we're down at 0.28 and 0.34. That 0.28 acre has 2,100 square feet. So when you look at the criteria that kind of gets outlined in the staff report under 3, literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same zoning classification. We think trying to hold us to 1,000 foot as the absolute maximum doesn't really jive with what's provided there. And then similarly, the same reason why 4 is not met is because they make the determination that the minimum variance to make reasonable use of the land. And that reasonable language is really what you're talking about here, is trying to be in compliance with the surrounding properties. Let's see. Just one second. Yeah. So one of the problems that we see with the interpretation as is, and if you try to hold that down to that 1,000 square feet, is that all of our property owners in our neighborhood, and that data is taken from the property appraiser's website for both the lot size and the size of the building. I didn't have surveys, so I can't tell you if any of them, all of them have variances, but the presumption would be for a 1/4 acre lot, there's probably at least 1 or 2 variances to be required. But if you had a scenario where a forest fire or a tornado or a hurricane came through and you exceeded that 75% threshold, all those properties that are sub-acre and over 1,000 square feet, under the interpretation, if you apply 3 and 4 as it's interpreted, could not be rebuilt in that way. So that doesn't really make a whole lot of sense as applied. Much more likely to say the reasonable size is what's being requested there. Let me pull forward, this is on the staff report. If you can pull up the staff report again that shows page 6 of 19. Again, this just kind of shows the footprint. You know, obviously our driveway has to line up with where Arredondo Grant is in our garage. So that 55 feet down on the southwest corner, that's our frontage, and then Arredondo kind of turns and it's about to turn and head to the north, just to the east of us by 1 lot. So as you can see where we've located, where our well is likely to be located up in the top west, and I think Mr. Costa, you had mentioned that in a previous application. Still got to go through the building process to verify everything here. But that really dictates a whole lot of what we're dealing with as far as where the septic field can go and giving us our best opportunity for that. So you can kind of see that between the angle and the presence of the septic field, what we end up asking for an encroachment, and you have encroachments and variances necessary for the west, the east, the south, and the north. And normally I don't like coming through with so many, but it is what it is dealing with, you know, A3 zoning on such a small lot. And we do have the variance for the 12 feet on the north side, and that's the only one that if we were at like R4, that would still need a variance, but we think reasonable given the surrounding properties. I'm really happy to answer any questions you might have, but we feel that what we're asking for is not shooting for the moon, in fact asking for keeping it within reason within the surrounding neighborhood. And if there's any follow-up questions, I'm happy to answer them after neighbors speak.
Okay. Do we have any questions for the applicant? Okay, we do have some public participation forms. I'll give you a chance for rebuttal after the fact. Okay. All right. One of those is Jacob and Teresa Wilkerson. Aren't they the applicants? Okay. No. Good morning. Could I get your name and address for the record, sir? And ma'am.
Yes, sir. My name is Jacob Wilkerson, 1265 Arredondo Grant Road, DeLeon Springs.
Teresa, 1265 Arredondo Grant.
Okay. You've heard the applicant. You'd like to something you'd like to say to this request?
Yes, sir. Sorry. We've been in that area for over 19 years, and we built our home. It was an A3 when we built out there, and we were required to have the 1 point or more acres to build out there. And we had to meet all of our setbacks and our requirements as well. the A3 zoning was adopted to preserve and protect small farms and personal and use, for the personal use and limited of, agricultural production. We believe that the property is it's under the buildable acreage. However, the reason the variance would be adversely affecting us is the fact that we did build out there for a reason, which was agricultural. The parcel that this gentleman is referring to, or that's on the variance here, is adjacent to our small farm. And we also have a home business there. We, over the years, have purchased additional properties. We actually recently purchased 9 lots that is above this gentleman's property. He's saying 12-foot setbacks and 20-foot setbacks. Well, he's going to be touching almost our property lines with this stuff. So we're going to be affected by this. Sorry. We have livestock. I have horses. And we bought additional properties over the years to add to the pastures, to have more acreage for my horses. We also have other animals that are on the property as well. Every home on Arredondo Grant, they did meet the standards. A lot of times, yes, they were built older, so they did meet standards back before A3 zoning was changed. But at the same time, we all have similar schemes, and especially on our side of the road. He's showing the other side of the road. Yes, it has built up quite a bit. There are properties over there that have other properties behind them that they have purchased over the years that have added to their own existing properties as well. So they're not like tiny, tiny lots and houses on top of on top of each other. And when we were looking at this also, the septic and the well being on the back side of the property, like I said, touches our area. And then the front, of course, we're concerned about that. We did touch base on some of the variance questions, the special conditions of the applicant's actions. We disagree. The applicant is a contractor. He's not planning to live there. He has a place here in DeLand. He lives there. He's planning to build and then flip. He's planning to put a huge monstrous house. We have 1,700 square feet. It's not the same. It's not the same.
So that was her 3 minutes. Do I get 3 minutes also, sir?
Yes, sir.
Yes, sir. Okay, so to kind of touch off of what my wife was saying, we have been there almost 20 years. My family's lived on that road for about 40 years. So we're well vested in the community out there. And what this house is doing, by bringing it in, not only are we looking to do away with the variance for the R3 for our agricultural, but now we're saying, okay, you give me that variance, and then I need 4 more variances on top of that. So now we're trying to bring it into the R category instead of the A3. Well, if we achieve that, then I need 4 more variances. So when we ask that it's not really asking for the whole lot. Well, you're kind of asking for a whole lot right off the get-go. We're circumventing the R series, which is there for a reason, to protect us out there in the rural community. We've bought property around us strategically, trying to consume as much property as we can so we can grow our lifestyle here in Volusia County, where we were born and raised, and that's what we do. We use it for a home-based building. So with that said, the contingency plan, looking at it, and as the attorney had stated, when you put the septic tank 5 foot off the front door, because that's the only way it's going to fit in there, what do you do with your driveway? You got your driveway coming out. Where's your sidewalks? What are we going to do with sidewalks? So it's just kind of, can we pull that picture up so I can look at it up there? Somebody got a picture of it? Because I think we got a 16-foot variance in the rear of that. So if we've got our agricultural horses and our cows at our fence, sticking their head over into the backyard, that 16 feet just became 13 feet to their backyard. So we're trying to protect our livestock. We don't want to put a house right there, and have 13 feet in between us when we've had nobody around us for 20 years. I'm all about growth, but put it in the right place. DeLeon Springs is not the place to start doing pop-up houses especially in the agricultural zone. I appreciate your time, and hopefully you guys will side with us.
Okay. Any questions for the speaker? All right, thank you, sir, ma'am. All right, we have a Cynthia Bloomquist. And if I can get your name and address for the record.
Cynthia Blumquist, 1735 Arredondo Grant Road, DeLeon Springs, and I have a form this time. I apologize for that. I'm just here to, I live down the road. We came before this commission about a year ago this time. We had the Scott family had a non-conforming lot that they were trying to develop and build. And we went through this whole process. We went before the county council 3 times. And at the end of the day, the county council decided that preservation of the A3 agricultural field that we're trying to maintain in DeLeon Springs was important. And they denied that. And that piece was 1.1 acres. So this is just a reminder that this is going to keep happening, that we're going to have builders buying non-conforming lots that they knew at the time of purchase were non-conforming because their intent is to hire an attorney and come before you and try to get a variance. And at some point, it should never even get to here. And so I'm just here to remind the county council and the public that zoning was made for a reason. And when you intentionally buy a piece of property to circumvent that, then they didn't do their due diligence. So we respectfully request that you honor the zoning as it is. Thank you.
Thank you. That does it for the forums on the public participation. Do we have anybody else in the audience who'd like to speak to this case? Hearing none. Okay, Mr. Woods, if you'd like
Yes,
to rebuttal
indeed.
on this.
Yes, I could. Let's go ahead. So respectfully, and to kind of reiterate, this isn't a question of whether or not a lot or home can be built here. This goes back to pre-2004, that when the zoning was changed, that there was a vested lot to be constructed. Now, that lot configuration was under the old style and standard, for sure, and it has since been enlarged in 2004 to minimize the non-conforming. It is still non-conforming, but that doesn't mean that it's not a buildable lot. Because if it were a non-buildable lot, at the imposition of that rezoning, the county would have had to pay for the lost value on that property. So the variance process is, yes, for the benefit of the property owner to build, but it is the pressure relief valve that allows for the county to come in and make a global change like they did and not be on the hook for taking different property rights. So again, a single-family home is absolutely allowed to be here. The issue that we take contention with is whether or not it's deemed as appropriate or not for the lot size and for the home that we are proposing. And again, with the presentation I made of all the surrounding homes in the area, and yes, it was on the southern side, and I'll show you what the northern side looks like. We are within keeping of the square footage and the lot size of those lots. Now, if you can show the overhead to, I don't know, can you guys see that right now? The overhead aerial photo? I see it on this screen, but I don't see it on here.
We see it up there.
Perfect. Okay. Okay, wonderful. So what you see right there are the lots on the north side of Arredondo Grant, and we are at the southwest corner of 1 and to the south of 5. And so what you have there are all the various lots that are not developed. And if you can see, and I know the yellow lines are kind of difficult, what you have running north and south are the platted, unconstructed roads. So if you look at the roadway that runs between 7 and 5 and 4 and 6 there, that's why we have to get a variance from a front yard setback on our property, because that right-of-way is technically still there. We're not asking for the vacation because, among other people, and you can if you can scroll that up just a little bit higher so you can kind of see the list of all the various property owners, you've got a bunch of different property owners that have acreage out there. But those lots aren't buildable or developable right now, invested for buildable lots, because they're not on a paved right-of-way. So, for instance, lots 4 and 5, which I believe is owned by the Wilkersons, if they also owned our property, they could then touch upon the roadway and the entirety of that would be buildable. Alternatively, they can come in and bring a roadway up to 4 and 5, but even there, 4 and 5, because they are not vested lots, they would still have to have the acreage combined, because 4 and 5 combined is about half, a little more than half an acre. They still have to go get another half an acre for that to be a buildable lot. And the only difference between our property and theirs is because we happen to have the fortune of being on a paved roadway, which is what the county used when they accepted the old platted lots and they tried to kind of clean this all up. So 4, 5, 7, 12, 13, 15, that's all Wilkerson related owned property there, and their main home there is number 15. If you can go to that next page there. You know, they've done a good job, and I understand, because they're like at 1.26 acres, and they've got frontage aplenty. Yeah, if you can slide that down just a little bit more, just so we can see the rear. They got acreage aplenty there, and they've got a squat wide lot, because for as irregular as our lot was, so was theirs, but to the good. But you can see there, you know, they've got a fence along the roadway, and ballparking, property appraiser's website isn't always, you know, the angles are a little tough. But their corner of their lot is 40 feet away from the property line on the south, because they are A3 and they are required to meet those setbacks. Now, I don't know that all the structures on the north side of there are 40 feet off the property line. There should be some wiggle room because of the GIS and how that lines up. But that gets back to my same argument that if a tornado rolled through here, that property would have to be compliant with the setbacks, or they're going to be in the same situation as we are, asking for a variance. So what we're asking for, and again, going back to the property to our north, yes, we're 12 feet away, and you can make a condition that we keep that 12 feet natural if you so choose. That could be fine. But the idea that right now there's no active pasture land there, and they'd have to do some substantial work to be able to bring that. And I don't know if there's an relief, because if you could go back to the other slide. I don't know if there's relief with 4 and 5. I know you couldn't build a home on 4 and 5 right now. Could you clear it and do agricultural use sub 1 acre right now? I don't know. Maybe so. But even if they can, and even if they do, we can still keep our 12-foot buffer and they'll still be fine. So I think what we're asking for is in keeping with the surrounding property. And again, if you've got any specific questions, I'm happy to answer them.
Thank you, Mr. Woods. Any questions for the applicant? Okay. All right. We're going to close the floor for public participation, open up for commission discussion. We have to take each case individually. I know that one case we approved and then they went up on appeal and got denied. I mean, we've reversed on our decisions. So.
Mr. Chair, I just want to clarify. You're talking about the Scott property. That's a different type of variance. That was a variance to separate lots. That lot that the Scotts owned, that was not a vested lot. That was kind of, I don't want to say illegally created, but it was not created according to the provisions. And what came before you was the applicant requesting, the actual ability to build on the lot. There wasn't a discussion on setback variances because, it was an illegally created lot.
Right, that was the point I was getting at. It's separate from what we're discussing today. I mean, I realized that because we were on this, some of us was on the board then, and we went through that. So, but we have to take it each individual case also. Look at individually. So, in saying that, any discussion, or I will entertain a motion if you'd like to entertain a motion to bring it forward.
I just have a comment. Mr. Woods made a comment about if we wanted to talk about the rear of the property and have some sort of buffer built in there or something, if that's something we would entertain. I'm just asking. He said they, if I said it correctly,
I
that
wouldn't
they
be,
were
I wouldn't
open
be
to-
opposed to having a buffer built into this variance.
I would feel much more comfortable,
That would apply to variance number 2, I would imagine.
correct?
Mr. Woods, would you like to clarify that?
Yeah, I think my main concern there was to ensure that wherever that porch area was coming closer, because that's what's prompting that variance number 2, to screen that area. I don't want to make it overly complicated, but I also don't want us to then get kind of pinned down by the well in the northwest quadrant, because they're going to definitely
Exactly.
need that well location to be. But let's just say any of that variance 2 area, because I think the condition that the staff required, if you do approve this, is with our site plan as proposed. So let's say that anything adjacent to that porch area needs to retain that screening because of the proximity to the property line. I think that would be real easy to be able to
You're comfortable with
accomplish. I think so, yes.
Mr. Soria?
Yeah, because I understand Mr. Woods' issue. If you required a 12-foot buffer along the entirety of the northern property line, you're wiping out the well. You couldn't clear it.
Right.
So my understanding, there would just be at least a 12-foot buffer where the I guess the requested variance area was. So that 26 feet of porch area needs to have that. At the very least, needs to have that 12-foot undisturbed buffer associated with it.
Okay. So you got that, whoever's gonna make the motion?
Go ahead, Ms. Shaw. Go ahead, make the motion.
Can't make the
No,
motion.
not
he's
you, I was
talking to me.
I was talking to her.
Yeah, these, yes, I've been,
Good, but I'd have to give you the gavel.
you know, I understand. These are always difficult. They're not, these decisions are not easy, but I would like to go ahead and make a motion that we approve case number V-24014, subject to the one staff condition and with the addition of a 12-foot, was it 12 feet?
Yeah,
Was that-
yeah,
okay.
a 12-foot buffer
buffer
along the.
Northern property.
northern
Yeah.
portion of the property outside of the well field.
Well,
I would say
yes.
variance 2.
Yeah, where variance
It's
2
two.
is applied.
Okay, thank you.
You're approving all 4 variances, correct? 1 through 4?
Yes, sir.
Okay. Second.
Okay, I got a motion on the floor to approve variance V-24-014 with the 4, for all 4 variances, with the one staff condition and also the condition of a 12-foot buffer on the portion of variance 2 along the porch area. Any discussion on the motion? From Ms. Shelley and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
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 Opposed?
No.
Okay, motion carries
5 to 1.
4 to 1. No,
5 to 1.
5-1.
5 to 1.
Thank you very much.
You're welcome. Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-24-17017, variances to the minimum yard requirements and accessory dwelling units, ADU regulations on rural residential RR zoned property.
Thank you, Ms. Shelley. I gotta get up on this thing, and this is Mr. Hanson also.
Good morning, once again, Michael Hanson, Planning and Development Services. This is the last one I have for you today, but this particular variance application includes 4 variance requests. It's located off of Glen Drive and New Smyrna Beach. It is a corner lot, and what we're looking at doing possibly is requesting variances for the construction of an accessory dwelling unit. As you see on the variance site plan in front of you, the new cottage, as is listed, is the proposed accessory dwelling unit. It has 1,036 square feet, as it states, and that value is greater than 50% of the living area of the principal dwelling unit. So the principal dwelling unit was built back in 1978, and when we're looking at a living area, we deduct any kind of unconditioned space from it. So although on the site plan, it says it's 2,200 square feet. We deduct the unconditioned porch area or the garage. So based on the condition area of it, we ended up at getting data from the property appraiser's office, putting it at 1,524 square feet for the main house. Also, I had a conversation with the property owner that there's an existing enclosed porch on the rear of the property, so it is thermal controlled and conditioned. That adds another 312 square feet, which brings the total livable area of the principal dwelling to 1,836 square feet. So the size relation that we're looking at for this accessory dwelling unit ends at 56.4 feet. So it's essentially a variance request in towards the size of 6.4%. Now, we have other variance requests related to the accessory dwelling unit that deal with the location of it. So on properties less than 1 acre in size, accessory dwelling units are supposed to be rearward of the rearmost facade of the principal dwelling unit. This is a corner lot, so it has 2 front yards. It makes it very difficult to do so. It would end up putting the ADU in the northwest corner of the property where there's actually an easement and there's an existing carport and a shed in that area. So it limits the applicant's ability to do so. So that's why they requested it in the area that they're looking at. And that's where we get variance too. Now, based on the location of it, we're also looking at a variance to reduce the 40-foot south front yard to 31.5 feet, as the applicant's looking at creating a covered walkway, essentially linking the principal dwelling with the proposed ADU. Because it's covered, that's why we require a variance for that. So if they constructed that walkway with just pavers and no covering, that wouldn't actually require a variance. Variance 4 is one to legitimize the location of the actual house that was built in 1978. In the current zoning classification for rural residential, it requires a 40-foot front yard setback. But as you can see on the variance site plan, there's a distance of approximately 30 feet from the front yard. And so variance 4 was added by staff to legitimize the location of the house. And the reason for that is the particular property went through an administrative rezoning with the adoption of the comprehensive plan, which changed the zoning to RR to increase the setback from the 30 feet to 40 feet. So at the time of its creation, the house met the required setbacks at the time. In review of the application, we have variances 1 and 3 have recommendations of denial, noting that they each fail to meet 4 of the 5 criteria. Where staff has recommendations for approval on variances 2 and 4, noting that they meet all 5 of the criteria. I do have one staff recommendation. Should the PLDRC find evidence and support to approve the variance request as is shown on the screen. I'm available for any questions you may have.
Thank you, Mr. Hanson. Any question for staff? Mr. Costa?
Yeah, I just want to clarify, make sure I heard you right. So variance number 4 was not requested by the applicant, but it was put in by staff?
That's correct, sir.
All right, so just 1, 2, and 3 are the only ones the applicant put in, and we are in a corner lot here. I was a little confused with the whole explanation of the main residence. So you said the total under air was how many square feet?
Including the enclosed rear porch, it ends up at 1,836 square feet.
1,800 under air, but under roof is 2,200 plus?
That's correct.
Okay, thank you.
Any other questions for staff? Is the applicant present? Good morning. Could I get your name and address for the record?
Good morning. I'm Amanda Richardson. I live at 617 Goodwin Avenue, New Smyrna. Just a little summary of what we're trying to do and why. This is my grandmother's home, and our main goal is for her to be able to age in place. So the plan is for my husband and I to move to the principal dwelling at this Glen Drive address, and then my grandmother would be living in the accessory unit. For the two variances that were recommended for denial, the first, the calculation of, or I guess, I don't know which one it was, but the square footage. The garage is enclosed and under air in the main existing house. So that was not included in the figure the county provided for the square footage of the house. So if anything under air, you know, it's a finished garage, you know, carpeted, it's a playroom, actually, and is under HVAC. So that would bring the total square footage of the main home to 2,287, which then does put us within the 50% requirement for an accessory unit. So that one, we feel should be approved respectfully. And then the first one, I'm sorry. Sorry. Oh, yes, so the third one is the covered walkway. So the covered walkway, we had proposed with the intent of just ease of access for my grandmother to go to and from each of the residences, but also for emergency service access and handicap capabilities. We plan on making the accessory unit all handicap accessible if she were to need that in the future. And that covered walkway, while, you know, we could handle it not being covered, if she needs emergency services, it would certainly ease that access from the main drive, which is on the sort of left side of the main house, all the way over to that right side where the accessory unit is planned. She has had emergency services out to her home at least twice in the last 12 months for ongoing heart issues, so that is a reasonable concern that we have.
Okay, any questions for the applicant? Okay, hearing none. Okay, hold on a moment.
I do have a question for you. Any conversation with the neighbors on
Yes.
this?
We have, go ahead, Nanny.
Let me get your name and address for the record, ma'am.
Hi, my name is Eloise Cartwright, and I have spoke to my neighbors. I've been there almost 15 years, and they're very happy about they're all pretty close to my age, which is old, and they're very happy about it.
Okay, would you give me your address, ma'am, please? Your address.
Oh, 2511 Glen Drive.
Thank you. You want to live next to your granddaughter?
Yes, yes, I would.
Yeah.
She's a good granddaughter.
Yeah.
And I'm not there yet, but I'm 81, and you know, and I will be needing help.
Okay.
But I want to be independent. I don't want to,
Yeah,
you
but
know, be
absolutely, I
a
understand.
pest.
I understand. Any other questions for the applicant? Okay, thank you, ma'am. Okay. All right, do we have any public participation for this case? All right, we're gonna close the floor for public participation, open up for commission discussion or a motion.
I have a question.
Go ahead.
About the garage, under air conditioning with an air vac and all that sort of thing, how did that not change the?
So at the time of the report, we didn't have the information that stated the garage was a conditioned space. I had a conversation with the property owner that clarified that the rear enclosed porch was conditioned, so that's how I was able to add that. So I just did some quick calculations. If the garage is enclosed and thermal controlled with air conditioning, then it would technically meet the definition for livable space, in which case then variance 1 wouldn't be required because the proposed size of the ADU is 1,036 square feet, so it'd be under the 50% threshold of the 2,200 square feet.
Go ahead.
Just another question, would we have to go out and would that be a condition that it would be confirmed? That
I
if
would
we-
recommend that if you are going to approve this, that you just grant the variances
Yeah.
Okay,
anyway.
thank you.
Because the word
Yeah.
if.
Yeah, I don't want to leave this up to something we can't verify for 2 years, and it puts them in
Perfect,
limbo.
okay,
I'm
thank
ready
you.
to-
That's
ready to
the
make a motion.
suggestion I was gonna
Clarify
make.
that, yeah.
You ready? So I make a motion on case V-24-017 that we approve variances 1, 2, 3, and 4 with the one staff recommended condition.
Second,
Okay, I've got a motion on the floor from Mr. Costa to approve variance V24017, variances 1 through 4, with the one staff condition, and a second from Ms. Shelley. Any discussion on the motion?
I would say that the purpose of the ADU when it first came about was for this exact particular purpose, not necessarily for rental income, as some people are using it, but for this particular purpose is to basically take care of our aging parents and population. And I think this is a well-deserved variance grant if it's so voted.
And I think we're going to see a lot more of this. So.
I have to concur with you on that.
Yep.
Okay, all those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-24-018, variances to the minimum yard requirements on rural residential RR zoned property.
Okay, Ms. Ray, this one is yours.
Good morning, Kristen Ray. The applicants are seeking variances for a proposed 840 square foot garage. Variance 1 is to reduce the west rear yard from 40 feet to 9.26 feet. Variance 2 is to reduce the north rear yard from 40 feet to 37.57 feet. This property is unique as it is located at the end of a cul-de-sac, so it is subject to 1 front yard, 2 side yards, and 2 rear yards. Accessory structures that exceed 500 square feet in area are required to meet principal setbacks. Excuse me. Staff's recommendation is for denial, as the structure could be relocated to meet the setbacks. However, should the PLDRC find that the applicants have provided competent substantial evidence, the following condition has been provided for consideration: that variances 1 and 2 are limited to the size and location of the proposed garage as shown on the variance site plan, and I'm available for questions.
Okay, any question for staff? Okay, is the applicant present? Name and address for the record, sir.
Alan Sandy, 985 Gerald Way.
You've heard the staff report. Anything you'd like to add to it?
The reason I'm really wanting this variance is, like she said, I have 2 backyards. According to them, it's 40 feet. The one I'm 37 feet off of it, but there's a bunch of trees that I don't want to cut down. And if I move it even at 3 foot, I'm going to have to take out about 6 trees, which I don't want to do. And if I move from the 9 foot up, I'm going to take out at least 7 trees. And I just don't want to take any trees out of my yard. So it's,
Right.
and there's no houses on the any properties. I got 3 letters from my neighbors, different neighbors that are fine with it. The closest house is probably 900 feet away.
Okay.
So.
You can submit them to Ms. Tucker to my left there, and she'll make them part of the record. Okay, in my discussion with you, as I spoke earlier that I'd spoken with you, one of those trees are even protected. Is that not correct over there on the left side? Okay. All right. Any questions for the applicant? Okay. Do we have any public participation for this case? Okay. All right. Thank you. We're going to open up the floor. We're going to close the floor for public participation and open it up for commission discussion. I will say this is one of those lots that is almost, as a matter of fact, it's actually worse than a corner lot because it's on the end of a cul-de-sac. And the way that it's situated there, he's pretty much, his setbacks are more than it would be on the normal lot size. Not only that is, here we are dealing with the rural residential, which the setbacks are greater than what you would have on a regular residential property. So I don't think this is too much of a question to consider as far as applying the variances.
Yeah, I'm very, very familiar with this street. Very well done, very well laid out, but there are some strange property sizes on this. I'm ready to make a motion.
Okay, go ahead.
Okay, I'll make a motion for approval of case B24018 with the one variance.
One condition, yeah.
The one condition, yeah.
Second.
That's 1 and 2, correct?
One and
Variances
two, yeah, one and
Okay.
two.
Okay, I got a motion on the floor to approve variances 1 and 2 for B 24018 with the one condition from staff and from Mr. Sixma and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries unanimously. Okay. All right. Ms. Shelley, can I get the next case, please?
Yes, sir. Case number S-24-001. A special exception for a communication tower exceeding 70 feet in height on forestry resource FR zoned property.
And this is Ms. Ray also.
Hello, so the applicant is requesting a special exception for a 255-foot self-support communication tower on a 40-acre parcel. The parcel is surrounded by Lake George State Forest and agricultural properties. The property is currently heavily treed with agricultural structures to the northern portion and a mobile home to the southeast corner. The proposed lease area is 10,000 square feet, located, on the southeast portion of the property, approximately 540 feet from the mobile home. This tower is proposed to accommodate 3 tenants, with AT&T being the initial leasee. There is a proposed 30-foot ingress-egress and utility easement with access from Harper Road. The project is not expected to create undue traffic congestion, as the site will be visited for maintenance use only. It is unlikely to be a hazard to the area, as the fall radius is 155 feet. So if it were to fall in any direction, it will remain on the 40-acre parcel. We did receive a letter from the Federal Aviation Administration also stating that the proposed tower will not be a hazard to the air navigation. Staff recommends the PLDRC for the request to the County Council for final action with a recommendation of approval, subject to the conditions listed on page 9. I'm available for questions.
Any questions for staff?
Yeah, this if I'm reading this right, this is still inside the bombing range zone. Is that correct?
Yes, sir.
Do we have any? I don't think the FAA has jurisdiction over that area. That is the military, correct?
So I did reach out to our Navy representative, and he had no objection as long as there was no hazard from the FAA.
That was my question. Okay, thank you.
If not, they blow it up.
Okay. All right, and any other questions for staff? All right, is the applicant present? Good morning, sir. Could I have your name and address for the record?
Good morning. Yeah, my name's Mike Nix, and I'm at 3132 Winding Pine Trail in Longwood.
All right, sir, you've heard the staff report. Anything you'd like to add to it?
Can't think of anything at this point.
Okay. I have one question for you. I noticed this is it an AT&T tower?
It's actually going to be owned by Vertical Bridge, and they're going to locate AT&T on the top. They're in the business of leasing
Right.
out the vertical space.
That's what I was going to ask you. Is you're doing other providers if you can come to a negotiated deal, correct?
Exactly. That's kind of the business plan. So
Okay, yeah.
So we encourage co-location.
So there will be space for other providers, is
Yes.
what I'm asking. Okay, well, that's good. Okay. Any other questions for the applicant? All right. Let's see if we have any public participation. If not,
Thank you.
then we'll move forward. Anyone
Probably.
like to speak to this case? Hearing none, all those, here, I'm getting ahead of myself. I'm going to close the floor for public participation and open up for commission discussion.
Probably out in this neighborhood, this is much needed.
Let's start
Probably
with,
no reception out there.
I'll make a motion, case S-24-001, that we forward the special exemption case to the county council for final action with a recommendation of approval with
Second.
staff recommended conditions. Still a second?
Still a second?
Second, yes, sir.
Okay. I got a motion from Mr. Costa to forward the special exception case S-24001 to the county council for final action with recommendation of approval, subject to staff recommended conditions. Any discussion, and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
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 Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes, sir. Z-24-004, rezoning from the general commercial B4 and urban single-family residential R4 zoning classifications to the urban single-family residential R4 zoning classification.
Thank you, Ms. Shelley.
Would you like me to read?
Is
Do
that got a
both?
companion case?
There's a companion case with it.
Yes. Go ahead and read both of them into the record.
All right. And case number V-24-015, variances to the minimum yard requirements on general commercial B4 and urban single-family residential R4 zoned properties.
Thank you. Ms. Ray, this one is yours? Or both of them are yours?
Yes, sir. So this is a rezoning of a 38,642 square foot parcel from split zoned B4 and R4 to R4. This is to resolve the split zoning and conform to the zoning ordinance. The parcel is comprised of 2 lots. The first, the lot to the east, the B4, was purchased, and then the R4 to the west was purchased and then combined in January 2023. It is developed with a 2,544 square foot principal structure on the northeast corner. It is currently being used as a house of worship and there is a parking area just below it. The existing future land use is urban medium intensity, UMI, and the proposed R4 is assumed compatible. The anticipated trips are not expected to change, as a house of worship is still the current use and is the proposed use for the future as well. Staff's recommendation is to forward to the county council for final action with recommendation of approval, and I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Okay, is the applicant present? Good morning. Could I get your name and address for the record?
928 Sycamore Street, Daytona Beach, Florida.
All right, Mr. Hoover, you've heard the staff report. Anything you'd like to add to it?
No, sir, I don't. Don't have
Okay.
anything to add.
Any questions for the applicant?
Just looks like your neighbors are supporting you. I
Yes,
like to
sir.
see that when we're looking at these variance cases.
Okay. All right, sir. I just wanted to, we had one of the zoning cases pulled, 03?
Yes, so if you want me to go ahead, I can read the variance staff report as well.
Yeah, it was
Go ahead and let's
not
put,
yeah,
do the variance also.
we're on 004.
Yeah.
Yep.
Because I had the letters of opposition on variance Z03 here. What is
That's
this?
the last
That's the very last case.
The last
okay.
case. We have 2, yeah.
But it says zoning, that's the reason I asked. Okay, go ahead. Ms. Ray, you would like to bring forward the variance case also?
Okay, yes. So with the rezoning, the applicant is also requesting 4 variances. Variances 1 and 2 are for the existing house of worship. Variance 1 is to reduce the east side yard from 50 feet to 10.7 feet. And variance 2 is to reduce the north rear yard from 50 feet to 13.5 feet. Variances 3 and 4 are for the proposed 3,399 square foot addition. Variance 3 is to reduce the north rear yard from 50 feet to 13.5 feet. And variance 4 is to reduce the west side yard from 50 feet to 36.5 feet. The structure was built in 1995, originally as a commercial building. The owners purchased the property in 2012 and changed the use from commercial to a house of worship, which added additional regulations. House of worship no principal or accessory structure shall be located less than 50 foot from any property line. Staff's recommendation for variance 1 and 2 is for approval, and staff's recommendation for variances 3 and 4 is for denial. Should the PLDRC find that the applicant has provided competent substantial evidence to support approval of the variances, the following condition is provided for consideration: that variances 1 through 4 are limited to the location of the existing house of worship and proposed addition as shown on the variance site plan. And there are 3 letters of support from the neighbors to the north, east, and west. And I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? All right. Is there anything you would like to add to this, Mr. Hooger?
Basically, listening to the previous justifications for requesting your approval, they alluded to the other zoning requirements. We would just ask that you take into consideration the neighbors are in total support for this addition.
All right, sir. Any questions for the applicant? Okay, do we have anybody to speak on the variance case? All right, we're going to close the floor for public participation and open up for commission. We're going to take the zoning first.
Yep. Ready to make a motion, sir?
All right.
All right. On case number Z-24-004, make a motion that we forward the rezoning application to the county council for final action with a recommendation of approval.
Second.
Okay.
You want to make both motions or take a vote on this one first?
No, we'll take a vote on the first one because the first one don't go, then the
Okay.
second one.
Go.
Okay. All right, we do have a motion on the floor to approve, forward the rezoning application case number Z-24-004 to council for final action with recommendation of approval. And a second from, first.
Me. Second from me.
A motion from Mr. Costa and a second from Ms. Shelley. There we go.
got it.
I'm getting tongue-tied here. It's getting late in the afternoon or morning.
Late in the morning, yeah.
Okay. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries unanimously. Okay, since that passed, we'll go ahead into our variance.
I'd like to make a motion, Mr.
Can I
Chair.
ask a question?
Yes.
May I ask a question? I was just looking at this. When we did the variances, are the variances are based on the B4 as it being remaining the B4? It does, or you've taken into consideration that it might be the R4 because that's not what the subject says. So
Yes, ma'am. So with the house of worship, there is an additional regulation that no matter which zoning classification, there is a 50-foot setback for the principal and accessory structures.
Thank you.
You're welcome.
Okay, go ahead, Mr. Costa.
Case V-24-015, make a motion that we approve variances 1, 2, 3, and 4 with the one staff recommended condition.
Second.
Okay, I've got a motion to approve variance V-24-015, variances 1 through 4 with the one staff condition for Mr. Costa and a second for Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any
Aye.
opposed? Motion carries unanimously.
Thank you.
You're welcome, sir. Ms. Shelley, could I get the next case, please?
Yes, sir. Case number Z-24-003, a rezoning from the rural residential RR zoning classification to the urban single-family residential R4 zoning classification.
Okay. Thank you, Ms. Shelley. Ms. Ray, this is yours. This is why I was getting confused. We put
Yes.
003 and 004.
I was too earlier.
I was getting a little confused there. Sorry about that.
No worries. So the applicant is requesting a rezoning of a 4-acre parcel from rural residential RR to urban single-family residential R4. The intent is to subdivide into 10 lots for single-family residences. So the surrounding area is developed with single-family residents. The proposed lots are similar in lot area to the parcels to the west, which provides a consistent developmental pattern. The existing future land use for the subject property and the surrounding properties is urban low intensity, and the proposed R4 zoning is conditionally compatible. Excuse me, sorry. Staff's recommendation is for the PLDRC to forward to County Council for final action with the recommendation of approval. There is 2 letters of opposition that have been received from adjacent neighbors to the west and to the east. And I'm available for questions.
Any questions for staff? Okay, I do have a question. This rezoning request, would that not be considered an enclave? Because even though the addition across the street is zone R4?
Not necessarily. You look at the land use. Really, what you're looking at is whether or not you're creating a spot zoning scenario, such as, you have a one piece of property that's zoned one, designation, and completely surrounding it is a property that's zoned within a completely incompatible designation. So that's kind of the criteria. There's no real enclave provision. You're really looking at, are you creating a spot zoning scenario? And the primary function is, okay, you look at the comprehensive plan. Here the comprehensive plan says that, in ULI, the R4 is conditionally compatible, so you do an extra compatibility analysis to it. Compatibility does not mean the same. It means, can these 2 uses that are adjacent to each other coexist over a long period of time?
Okay, that's my question. Any other questions for staff? Okay, I see you're there. Go ahead, Mrs. City.
Good morning. Thank you, Mr. Chair. For the record, Nikki Hosseini with the law firm of Cobb Cole, 231 North Woodland Boulevard in DeLand. And I'll just get started, Mr. Chair, on what you mentioned. So it's a little bit difficult to see on this map that you're looking at, but when you zoom out, it's much more clear. You'll notice that everything around the site, so to the left, to the right, and below it is already zoned R4. The only reason you'll see that big kind of swath of land below it is because that is a communications tower. And so that is owned by WESH, and that has remained a communications tower, but it is zoned R4. It is actually this kind of strip of RR that bleeds into the R4 that completely surrounds it, both on the other side of the street, other than that piece of that strip, on the left, on the right, and below it. So, obviously annexation, that issue would be for an enclave. This is already annexed. It is consistent with the zoning around it. It is simply actually removing part of that sliver that has gone down and encroached into the rest of the R4. And so a couple of items here. One, we're looking at really trying to be very consistent with the neighboring areas. So you'll see, Kelly, if you don't mind pulling up a site plan, this is just an idea of what we're looking to do, and shows that at maximum we could probably get around 10 lots, and that's over what's permissible, and we did that on purpose. So we have about around 0.2 acres per lot, which is only actually requires 7,500 square feet in R4. And the reason we did that was very intentional. It was to make sure we were consistent with the other R4 areas that are closest to us. Thank you so much. Another thing that we did, and you'll see those 2 strips of green that run down that are closest to the surrounding properties, that's tree preservation area. Those areas won't be touched. Those areas will be, as currently is now, full of trees. And so we're looking to build internal to that. So there'll be a fence. There'll be those 2 strips of tree preservation area as stormwater to the south. And then you're going to have your lots, which are almost more than and similar to all of the lots on the west. So one of the letters of opposition you received, spoke about how, that she lives in, one of the lot 48, lot 47, kind of on that left-hand side, and noted that it's a rural area and she wants it to keep her rural zoning. Well, she's zoned R4 and has a lot that is less than the lots that we're proposing to build adjacent to her. So honestly, the goal here is simply to be able to create a very cohesive community rather than doing this, one by one, having one house come together. It's really beneficial to do it cohesively, because then the land development code requires tree preservation of 15%. It requires certain heightened standards when you're doing a more master plan development. It requires certain stormwater provisions, certain open space, things of that nature, where when you had subdivided in the past, it never required those. And so, again, this is just a fairly rudimentary kind of rendering of what we intend to do, looking at, around 10, likely less than that once it gets through engineering. But we are very consistent with all sides. And I understand that there are some concerns with the neighbors that their lots are larger, but it is, again, like Kristen noted, consistent with the entirety of the area. And I likely foresee it eventually becoming all R4 in that area, as that seems to be the most consistent zoning. So I know there are some individuals that want to speak, but I'm happy to come up here and answer any of your questions.
Okay. Any questions for the applicant? Mr. Costa?
Are there services out there? Or is this going to be septic, the whole project?
I don't think we're there yet to
Okay.
figure out what it's going to be. I think it may be septic.
But there's no county services currently. There's no sewer service out there.
I think that's the Orange City service area.
That's Orange City?
It is
Oh,
within the
okay.
service area? Okay.
All right, thank you.
Okay. I'm going to leave my questions for the end. Okay. Thank you very much.
Yep, of course.
Okay, I do have some public participation for Ms. Kuffner, Carrie Kuffner. Oh, Mr. Kuffner. Sorry about that.
A picture of all the lots, please.
Okay.
Not her lot, but the first one you had up there. My name's Kerry Kuffner. I own actually the 2 lots on the east side of this property, which is a total of 5 acres, 2.5, 2.5.
Okay, I need to get your address also, sir.
One's 1280 West Blue Springs Avenue, Orange City.
Okay.
And the other one's 515 Manatee Springs Court.
No, your
Orange City.
address, your physical address.
1280 West Blue Springs is my
Okay.
residence.
All right, thank you, sir. Okay, and you were saying?
If you look at the picture where they're wanting to subdivide this lot, if you look south, which she is correct, is the West Tower property where nobody can build on it. And by the way, I've been on this property since 1989 on my property. If you look east, south, and north, you can clearly see every lot that they're wanting to rezone is large lots all the way to Sparkman Avenue, all the way to French Avenue, and all the way to the high school behind us, which the tower owns. So those lots are continuous from 2.5, 1.5, 5, and 10-acre lots, all the way. There is the only subdivided lots are west of this property. The other 3 sides are all big properties, and that's the whole reason why I invested almost $1 million in 2 homes, because I knew nobody could put 10 houses on the west side of my land. Mr. Gale used to own that, which passed away, and he was only going to put 1 house on it. And that's when I found out what it was zoned for, and that's the whole purpose where my whole family lives here. And the whole neighborhood is on board against this, but unfortunately, we didn't have enough time to get everybody. The only house that is for this is 1355 West Blue Springs Avenue, and that's the very people that are trying to get this subdivided. The rest of the neighborhood is totally against it.
Okay.
And another problem is I have a gun range, and you have to have all sides of your property 1 acre or more in Volusia County for me to keep that gun range. So if they approve this, not only am I going to have 10 neighbors on my goat farm up next to my fence on both properties, but I'm also going to lose my gun range.
All right, sir. Any questions for the speaker? All right, thank you, sir.
Sir.
Okay, Mr. Mark Burt?
One thing I noticed is dig deep on the actual existing.
Good morning, sir.
Good morning.
Could I get your name and address for the record?
My name is Mark Bird. I live at 1281 West Blue Springs Avenue, which is north and east. I'm the first 1.25 acre property northeast of this proposed area. Just for clarification, we do not have sewer services. That was one of my concerns. We're all septic out there, so that's going to affect the Blue Springs aquifer and the impact of the wildlife, because that is all wooded currently. I know it's currently zoned for RR, so they could put 3 homes there, but to clear this to put 10 homes, we're going to lose all that wildlife.
All right,
Those are all my comments.
Okay? Any questions for the speaker? All right, sir, thank you.
Thank you.
Miss Barbara Lovelady? Good morning, ma'am. Could I get your name and address for the record?
Barbara Lovelady, 1377 West Blue Springs. Excuse me, I have sinus problems. I'm against the rezoning to multiple housing. I understand that there is a chance that houses could be built on this present zone property, but I trust less chance than if it's zoned for multiple housing. I would love it if the woods were there forever. There are part of what makes our little neighborhood in Orange City a treasure. They offer a windbreak in a storm, a haven for the many different birds and wildlife, and the whole atmosphere brings joy and a peaceful place. Please let us enjoy God's comfort that he offers by keeping these woods free from complete destruction. Placing multiple housing there will not only change the whole area, but it will increase school crowding, crime problems, and to add to the terrific traffic problem we already have on Blue Springs Avenue. Please do not take away the privilege and pleasure we now have of a less crowded, not so busy feeling that we share. The only reason I can see for changing this zoning and adding many properties, people, and vehicles is plain greed. It's not progress or a benefit to our neighborhood. Tearing down these wonderful trees and depriving refuge, to wildlife and clogging up the environment with less free, clean air producers such as these trees are doesn't sound like a good plan for me. Please do not change the zoning to allow more houses. It will just destroy the whole pleasure we have in feeling like we have a touch of country right at our doorstep. Thank you for your kind consideration.
Thank you. Any question for the speaker? Having none, thank you, ma'am.
Thank you.
Miss Susan Zizio? And I may have messed that up.
My name is Susan Arnold Zizzo. I have lived on Live Oak Avenue. I'm at 436 Live Oak Avenue, Orange City. I have lived there since 1990, so almost as long as Mr. Kufner. My concern is, first off, because I live on Live Oak, that is not a through street. That is a dead-end street. We already have so much traffic that comes down through there on the wrong road. We have concerns, or I have concerns, my family as well, about the water, the sewer. We are on sewer and septic. We're on septic and wells out there. Also, lighting. We already struggle now with lighting out there. We need more. If we're going to do this, and I hope we don't, but we're going to have to think about lighting, the traffic congestion. We already have 3 schools that were built out there since I've moved out there. And we have so much congestion on Blue Springs trying to get in and out. It's crazy. I don't know if anybody else has ever been down that road, but what some of my other neighbors have stated to you is it's absolutely real. You cannot get down West Blue Springs at 4 o'clock in the afternoon because of the schools. I just see this getting more and more congested. We have a lot of building that goes on out there. And it's not conducive for what we want to live with, if that makes sense. So I am opposed to it, and I do live on Live Oak. I know my neighbors are opposed to it as well, and some of them couldn't be here. I took the day off to be here because this is important to me and to my family. Thank you.
Thank you. Any questions for the speaker? Thank you, ma'am. Okay, that ends it for the public participation forums. Anyone like to speak to this case? All right. Ms. Husseini?
Good morning again, and thank you. Just would like to go through some of their concerns because I think I can alleviate some of their concerns. The first gentleman noted that he bought those properties because he knew the zoning. It would not. There's nothing that could be built to the west, or really anywhere around him. Well, what's interesting is, other than that blue kind of sliver that you saw on the previous page, that kind of went up to the north, everything else is zoned R4. So whether it's the west or the east or the south, that's all R4. So all of that can be subdivided into 7,500 square foot lots. We're not even asking for 7,500 square foot lots. We want to build larger lots. And so just to verify, everything around it is in fact R4, other than those couple properties. It is 1, 2, 3 properties deep that is not zoned R4, and that kind of same train goes up, and that's the sliver. Everything else around it, in that entirety of that area to see on that screen, is zoned R4, and that's why you see how this is a pretty decent picture of, other than the communication towers, everything is subdivided, much more than it would be if it was RR, and so that's why it looks that way on that picture. Another note is, the individual wanted to say, keep it as woods. Obviously, there are property rights issues with that. I appreciate keeping it as woods. The benefit, again, here, doing it the way we're doing it, going through this process, is the fact that the county requires 15% tree preservation. So on both sides, so where she lives, there will be a massive buffer of current vegetation that's staying there that will count as part of that 15% of tree preservation area. So we are providing a buffer, we are providing those trees. With respect to schools and traffic, not really appropriate at the rezoning stage, but the subdivision stage, we have to meet concurrency. So if there is any issue with schools or traffic, we have to mitigate for that, or we can't build, we can't move forward. So concurrency is a requirement of subdivision. And so as we move forward with the process, we have to make sure that we account for both traffic and the schools. And lastly, the last individual that spoke about living on Live Oak, which is essentially what we're asking for here, the same zoning and the same type of lots. If you look at our plan, we don't propose using Live Oak. We create a cul-de-sac on purpose so that it is only a singular entrance off of Blue Springs where you can access every single home. So we're proposing only one access, and then obviously the county requires an emergency access just for fire trucks and emergency vehicles. But other than that, we are only asking for one access point off of Blue Springs. And so with that, I'm happy to answer any questions, but I think it's clear that the entire area, other than that tower, is currently zoned R4, and the houses are a little bit larger, other than those 3 deep next to the red one, which is the subject property. Everything else is R4. And so we're asking to also be considered as R4 and to be able to master plan an area that is cohesive and provides for that 15% TPA and those 2 buffers on both sides where the neighbors are. Thank you.
Any comments, Mr. Costa?
Yeah, so this is just a preliminary plan, and we can go put that back up on there, the overall development plan, please. And so you've got a large chunk of it for stormwater, and then you have 2 buffers on either side of the property.
Correct.
Looks like you have an easement so you can access the stormwater area. Is that correct?
I don't think it's finalized. This is very, very conceptual.
There's going to have to be some kind of an access easement
Correct.
to get to that stormwater for maintenance purposes.
Correct.
Now, outside of that, I'm reading on page 2 from the staff notes here that if there is in fact no central sewer system, that you're going to need to put an on-site treatment and disposal system, which tells me that, looking at the way this is laid out, you may end up losing a lot.
Most definitely. This is not
to
engineered.
accommodate that particular
Most
purpose.
definitely.
So this could go from 10 to possibly 9 or even 8, depending on the requirement.
Correct.
Okay.
It is
All right.
likely it will drop at least
This
2.
is a pie in the sky look right here. This is the
This
best case scenario if you
is the
could get it.
absolute maximum that
Gotcha.
could be on this lot. Has not
Understand.
gone through engineering. Will likely go down at least a couple of units.
Completely
correct.
understand. Okay, thank you.
Okay, on the flip side of that, though, if water and sewer were to become available, you could actually put 23 lots on this piece of property.
It's not possible.
Well, the staff report
It's
says that.
7,500 square feet required.
I think what is the density would support it, but not the minimum
Staff
lot size.
report said 23.
Right.
Yeah, theoretically, maximum of 23 dwelling units.
Wouldn't that be townhomes?
on page 3 of 21.
I'm not sure how that would be possible with the setbacks, the 15% TPA that's required, and the stormwater that's required. It was painful getting 10 lots on there.
Well, I think where I'm going with this is, for the fact of the matter is, you can't go with the 10 lots unless you put an on-site sewer. And so therefore, you wouldn't have the 10 lots. And then you've got your stormwater abutting RR zoning.
The stormwater is not abutting RR zoning. The stormwater is abutting R4 zoning.
Well, that sliver there showed that it was on the south side there. Let me look here.
So if you look at Blue Springs, right below it, and to the west side and the east side of that stormwater is all R4 zoning.
What about the south side?
R4, that's a communication tower. The south side of that stormwater management area you see up there, the south side is a communication tower.
Well, what I've seen in the past with these developments is they'll come in and raise the elevation. And when they raise the elevation to put the stormwater in, then you have a problem with that. And if you get utilities brought in, you're going to have a consumption permit, which actually brings some reclaimed water back in also. So I don't know how this can be developed with the 10-acre lots without public utilities. And if it was public utilities, the density would be greater than what it could be greater than what the 10 lots is. And the zoning goes with the property.
Correct.
Okay, so you're not locked into 10 lots maximum. Okay, because of the zoning itself, I don't know whether it's 23 or whatever it is, but go ahead, Ms. Smith.
Density is determined by the land use. It'll be capped at whatever the land use will allow. So it's 1 to 4. At the 4 acres would be a max of 16. That's a theoretical max, does not include the roads, the stormwater, and that's why Ms. Husseini is guesstimating at 10, but as this goes through engineering and as this goes through the health department, and they have to connect because they're in the Blue Springs PFA, they're going to need to provide land for that as well. So this site plan is very theoretical at this point, but would be capped based on density, not zoning.
So just to point that out, Mr. Chair, that's ULI. That's the underlying land use. So everything in this area that has ULI could have a theoretical max of a certain amount.
Sure.
It is physically impossible for this site to have anywhere.
What limits that is the zoning.
Excuse me?
You said theoretically it could have a
The
max,
land
but
use. The land use allows a theoretic max. When you look at the zoning and the requirements for the zoning, that is impossible. It is impossible to have 23 or most likely even 10 lots on this site. It will not go through land development and receive permits or anything else if does not meet the criteria. So you have to look at tree preservation, you have to look at stormwater, you have to look at the roads and all of that. So the land use simply provides a theoretic maximum. Whether it's R4 zoning or another zoning that has that underlying land use, that is the theoretic maximum base. Then you add on the zoning, and then you add on all the land development requirements. So I can tell you as a fact, and I'm not an engineer, but going through this process with an engineer, this is the maximum that the zoning will allow on the site, and it will likely decrease. It is impossible on this site to meet the land development requirements and go higher than what we have currently.
Okay. And what you said, why is that in our staff report? Where it says theoretically maximum of approximately 23 to what?
We always break down what you could do for zoning, but it will be always capped by the land use. And when this goes through our land development team, we in planning have a person who goes through every single application to calculate density. And it stops if he says this does not meet density, and that's based on land use.
Okay.
And you could do R4 zoning and potentially get 23 units on other properties. It's based on each site we look at to see if it can fit that. But it'll always be capped at land use.
That's a massive generalization on general properties, but then when looking at this particular site, this is what you're looking at. This is maximum and likely won't be met either. Like I see it as being around 7 to 8.
So from what I'm getting of this is though the intention is to try to get utilities there, public utilities there.
That's not the intention, no. We haven't even gotten close to that. That's very expensive to be able to bring public utilities.
Well,
So we're going to have to weigh our options, but we can't weigh our options if we don't have an approval. We're not going to spend more money on engineering and everything to see what the options are if we can't get an approval.
Okay. All right, thank you, Matt.
Thank you.
Okay, any other questions for the applicant? Okay, we do not have any more public participation forms, so we're going to close the floor for public participation, open up for commission discussion. And, okay, go ahead. Or a motion.
To the motion that we can discuss. I make a motion that we forward the rezoning application, case number Z-24-003 to the county council for final action with a recommendation of approval.
Second.
Okay, I've got a motion on the floor to forward the rezoning application case number Z-24-003 to the county council with a final action with a recommendation of approval from Mr. Costa and a second from Ms. Shelley. Any discussion on the motion? There again, my concern would be putting multiple, even though it's on the, I guess it's the west side, we have smaller lots, but to me, no matter how you look at it, it looks like an enclave to me. So, I mean, that's where I'm at with this. And because we have this site plan here, and that's probably not going to be what goes there, and that's been stated. It could be less. I don't guess it could be any more. How many more could it be?
I don't think it could be.
They would have to construct roads,
If we close-
stormwater, tree preservation. I mean, they would have to comply with the full subdivision process and plat, and that eats away at the land that can be used to develop. So buffers, tree preservation, stormwater, roads, subtract them all out, and then you work with what's left over. That's our modern subdivision process. Now, when 23 theoretical, assuming land use isn't an issue, say you have a very long R4 strip that doesn't require stormwater, doesn't require roads, doesn't require any tree preservation. Sure, you can hack it up in 23 separate units, but that's not the case. That goes through our land development process. They apply the code, and then out comes the subdivision.
What I'm thinking of is adjacent property owners, and what's happening is on a lot of these subdivisions, they're coming in and raising the elevations up if they were to get public utilities, and I don't know if they will or not. They probably won't. Like she said, it's very expensive. It's expensive now, but what about the future? They raise the elevations up, then you have to have your reclaimed water, and you have to have your storm water, and all this becomes a burden to the adjacent property owners. That's my concern on this. It'd be different if we had properties that was on most of it around it at the R4 zoning. That's my opinion. Okay, we got a motion. Anybody else like to speak about the motion?
Can I speak?
No, ma'am. I'm sorry, we've already closed it.
The kids come down that hill and they're scared.
I'm sorry, ma'am.
The kids are just gonna kill the kid.
Okay, we have a motion on the floor.
Motion in a second.
I'm gonna have to ask, please. All those in favor signify by saying aye.
Aye.
Any opposed? Aye.
You got two opposed. What did
I'm
Donna-
opposed.
How did Donna vote?
Opposed.
Could we please get a roll call vote?
Yep.
Do a roll call, please.
Member Craig,
Opposed.
Member Shelley,
Yes.
Member Costa,
Yes.
Member Patterson. Just for the record, that was a no from Member Patterson, Member Sixma,
Yes.
and Chair Mills.
No.
So you have a 3-3 tie vote. You need a majority. So, Mr. Chair, your options are you can, that is grounds for continuance. You can wait for a full commission. Someone can make another motion. Or you can ask for another motion and then deadlock, and then it goes to county council with, I'm going to call it technical denial because failure to obtain a majority vote for recommendation.
Okay. I'm going to ask Ms. Husini, would you like to continue it, or would you like to take it forward to council?
We don't want to continue it, we want to move forward.
Okay.
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 So moves forward for county council with a recommendation for technical denial.
Yes. Okay.
Do we need to make another motion, or we're good with what we have?
We're good.
Okay.
Okay. All right, that ends for the new business. If I could get, okay. If I could leave your, could I get you to leave the dais if you're gonna have a discussion, sir? We're done with it. It's
Done,
going to
yeah.
county council, if you can bring it to them. Okay. Okay, that's it for the new business today. We're gonna move on into other public items.
I have a, just have a.
Oh, yes.
I have to, I saved
gotta-
this, so I
yeah,
wouldn't
there you
forget.
go.
Those 2 staff recommendations. Oh, Mika, protect her.
That's out of my jurisdiction.
Me too.
It's okay. Does she feel like she needs an escort?
Okay.
Um,
Mr. Paulo, we're not sure if we put in the conditions on this one item earlier, and we'd like to relook at it to make sure the conditions were put in.
Sure. Because of the presentations of the staff report, I mean, that's kind of the staff's recommendation. So, you know, unless this commission specifically disagrees with one of the conditions, you know, they're going.
Well, she just wants to include them into the,
Yeah, I
I
think
didn't
you
make
could-
it in my motion.
I think you
so
could
I just-
clarify.
Yeah.
Yes, my understanding is from the discussion, it was, you know, the 2 conditions were posted on the screen. You know, I looked at them, I read them, so, you know, the whole discussion was those conditions were going into the actual motion. So I don't think you need to, you can clarify
we just
it.
want to clarify.
To clarify it.
We want
just
to
in case
clarify that
somebody
the
throws it.
conditions
I
are
mean,
included.
You never know. So I'd
Yes.
like to
What
put
was
it
the
in the
case
motion.
number?
Case number V-24-011. I know it was, they met 5 of the 5, but there were 2 conditions, so I would just like to make a motion to include the staff's recommended conditions on page 5 in our approved motion.
I get a second?
Second.
2 seconds? Okay. I got a motion to include the staff recommended conditions in our approval of V-24-001 from Ms. Shelley, and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries unanimously. Okay. Other public items.
So as we may have foreshadowed earlier, next month is a very busy month. You have 14 big items, and we also had the county council ask for PLDRC to review our special exceptions and make recommendations on how they should be heard, whether they should be heard by planning commission, or whether they should continue to go to council, or whether they can be a conditional use. So I have some homework for you. There is a 13-page spreadsheet where the staff has made recommendations on how we feel it should be handled. We would like to give you some homework to see if you agree with us. And when we come back in March, we're going to spend the first 2 hours as a workshop going through and getting consensus on how PLDRC feels. And then that will be forwarded to council, unless you have another way that you'd like to
Is
do
there a
with
video
that.
with the spreadsheet, or just?
I have instructions and a cover letter for you. And
Oh,
we'll hand it to you
amazing.
today, so you have a whole month.
I'm a visual person, so the more video we have, the easier it is for me to digest the information.
Now, the March meeting, that is at the end of our regular business meeting, the workshop.
Well, initially, we were going to do it in the morning and notify everyone who has cases that the cases will start at 11:30. We were going to start our meeting at 9, go from 9 to 11 with the workshop. feed you guys lunch, give you 30 minutes, and then let all our cases know don't come until 11:30. That's when cases will start.
Can't we do just the opposite?
First,
The
yeah.
reason being is because we may zip through this
We
quicker
can
than
do it the other way.
11:30, and then we would we'd be sitting around waiting for our cases to come in.
We could do it that way if you prefer. If, however, we get through the cases and then you don't get through the spreadsheet, we may be here very late in the evening. So it's totally your choice.
We might continue it. Yes. Yeah, I'd rather do that. One of the other things I listened to that discussion through the council, and I know it was brought up to have a joint workshop with the PLDRC board. And one of the concerns was you'd have 14 people there that would be, going, it would just extend it way out with 14 people. But can I make a recommendation that we have at least one, maybe two members of the board attend the workshop? See if council will go with that, because there are going to be some questions I know that's going to come up that we may be able to readily answer without having to go back to the PLDRC or without having to make
I think that's
uninformed
permissible.
decision.
At the March meeting, for example, if you have your discussions, you can designate one or two of your fellow commission members to attend the county council workshop, which will have public comment. They can speak, explain the discussion, explain the views. We would have to notice that, one or more members of this commission will be attending the county council workshop meeting. But that's completely doable. You can empower one or more of your members to speak on behalf of the board as a whole.
Well, what about instead of doing it the public participation, to be part of the workshop? Because you're limited to 3, and obviously, if you would like to interject a comment, you would not be doing that in a public participation format during the actual conversation of that. I mean, would the council go for that? You can run it by them.
That's up to the council.
I'm not telling them what to do or not to do, but I'm sure there's going to be things that come up, and there are comments that are going to be made that could probably be clarified, because we see these cases every day, or I say every day, every month, and we can give them a better understanding on the hurdles that we have to overcome in order to make our decisions.
I think we can make you available, just as staff is available if you've ever have to sat through one of these. So usually, our growth management director gets hauled up to the podium, sits back down, gets hauled back up again, answers questions. That's the type of participation I was thinking of with a member of the PLDRC, to answer any questions instead of being as part of public participation, basically a part of, staff making recommendations, because we are forwarding your recommendation to county council. So, whoever you would designate would be available to answer any questions that the county council would have on any of the issues. So, outside of the public participation aspect.
Okay.
But, I'll run it because we haven't set the type of format yet. The direction we were given was get PLDRC's input and then set up a workshop. That's it.
I heard it. And the concern to have the whole board there would be you'd have 14 members there, and you'd probably not get a whole lot done. And I understand that. I do understand that. Okay. All right. Any other public items?
So do we finalize March? Are we good with our March meeting?
You prefer cases first and then the workshop?
Yeah, I think that we should get the public out of the way first, and then we can conduct our business afterwards.
We will do that.
Even if we have to move it, down the block, we can do it there, since it is in fact just a review. If it goes after hours, just a suggestion on my part.
We're going to zip through that. We're all going to do our homework, and we're all going to come to a perfect agreement, and we're going to move on. Okay, do we have any other public items?
No, sir.
Staff comments?
No, sir.
Commission comments? Okay, press and citizen, we need to have that,
Left already.
that metal detector working for our meetings evidently.
Yeah.
I'm gonna stick around for a few minutes. I was taking a back door to get out of here. Press and citizen comments. We don't have anybody here. This meeting's adjourned.